Getting things started, and we are live and we are recording.
All right, I want to welcome everybody to the Ad Hoc Commission on the Discipline System. This is our April meeting, and I want to thank everybody for being here. Thank you to everybody listening in for your patience as we worked out some technical difficulties. And so, Justin, could you please take roll?
Sure. Anderson. Don't see Michelle at this time. Bell. Buenaventura.
Here.
Buffington.
Here, thank you.
Chen. I don't see. Duran. Eshardi.
Here.
Shadi. Farwell. Don't see. Good.
Here.
Jones. I just heard from you, Jenna.
I'm here, sorry.
Joseph. I don't see Milan at this time. King.
Here.
Larkin.
Here, and good afternoon.
Good afternoon. Lawrence.
Here.
Lear was not going to make it. Mayorga.
Here.
McGill.
Here.
Judge McGill. Okay. Moab.
Here.
Nakal. I don't believe is here right now. Pansky got pulled away. Rosenblatt. Eloise. Schneider.
Yes, I'm here.
Seleg.
Here.
Stallings.
Here.
Judge Wang.
Present. Good afternoon.
And Winfield. I don't see Martin as of now. 1, 2. We have a quorum.
Excellent. So I want to welcome everybody to, again, to the meeting, and just have a couple of introductory remarks before I hand it over to Justin and to Leah. But want to thank everybody for making themselves available. It has been a difficult proposition to get everybody's schedules to align. I think one of the benefits of having a large commission is that we get to take advantage of your talents and your expertise, and a definite downside is getting very busy people's schedules to align so we can have quorum for a meeting. So I think you're going to hear maybe a couple of those different themes throughout this meeting, but thank you for your work on this commission. We know that everybody is incredibly busy and sought after, and so we do not take your volunteerism for granted, and just want to extend our thanks for your care about these issues before us. And I also want to extend a huge thank you to staff, especially Justin, for your flexibility in getting these meetings scheduled. So later on in the agenda, we're going to talk about the need for several other working group meetings to be scheduled. So I just ask that people keep that spirit of flexibility in mind when getting these meetings on your calendar, so we can continue the work of this commission, and so we can get some work product finalized and on to the next step. So thank you. I'm now going to make a call for public comment. And Justin, are you going to be monitoring the line?
Yes.
All right. So if anybody wishes to make public comment on any items on this agenda, please raise your hand or follow the instructions if you're calling in, and then staff will call on you in order to maintain order of the meeting. Ask you limit your comment to 3 minutes. And so, Justin, do we have any individuals?
Giving a minute if anybody wants to raise their hand. I see, yes, I see one individual. Justin Beck, I have promoted you to allow you to talk. So if you unmute, you will have 3 minutes.
Yes, can you hear me okay?
I can hear you fine.
Great, thank you very much for your time. My name's Justin Beck, and I'm a member of the public who has personally experienced the trials and tribulations of the attorney discipline system in California. and specifically endured a number of damages as a result from the attorney discipline system. So I would love an opportunity to provide some perspective from the other side of the coin on the way that this system is not designed to protect the public. And I don't know if this is the appropriate forum, but I do appreciate everyone trying to improve the system, recognizing its failures. But I do think I have a unique perspective that I would love to share with this working group, maybe in a memo or something. And that really concludes my comments. Appreciate everybody's time. And again, I don't know if this is the appropriate forum.
Absolutely. You can make brief
Yeah.
comments now, and we'll be happy to receive a memo from you and share it with the entire commission.
Okay.
Thank you very much. I prefer to give you a memo so that we make the most use of everyone's time.
Okay, thank you. No one else has their hands up at this time.
All right, thank you for that public comment. And I can speak on behalf of the commission that we do review the written public comment is sent in, and so welcome any feedback from the public on ways that we can continue to do our job better. All right, moving on to the first item in our agenda. I believe that Justin and Leah are going to be presenting on this or a combination thereof.
Leah is going to take us through the first agenda item.
Great. So we had a request to take a look at the Client Trust Account Protection Program. This program was approved by the board in November of last year. And as a reminder, the impetus for the establishment of the program was the Girardi situation, as I'll call it. In light of Girardi and the special audit that the State Bar itself conducted in response, the board established the Special Discipline Case Audit Committee, and that committee is the entity that developed this proposed program that was then adopted and approved by the entire board in November. So I'm just going to take you quickly through its components. So the current state of affairs, this is very simplistic, but with respect to client trust account investigation or our oversight of client trust accounts is this. It's entirely reactive. We receive reportable actions from banks. We receive client trust account complaints, and OCTC investigates. So it's a reactive approach. The future state that's contemplated is much more proactive. And I'm going to take you briefly through some of the factors that led this Special Discipline Case Audit Committee to recommend a proactive approach. So first of all, we looked to our own history, and we saw that back in 2014, the board's Regulation and Discipline Committee had actually gone quite far towards developing an audit program. A consultant was hired to develop a program. These are some of the elements of the program that you see listed here. However, the initiative, after some funds were spent on it and a report was generated, was dropped. And it does appear to have been dropped just simply based on a change in the leadership of that committee of the board. We also looked at other states, and I'm not going to go through this in any great detail, but the point of this is there are many other states that have random audit programs of client trust accounts. And you can see the year of their origin, and there's plenty of detail here about what those programs consist of in terms of size and volume. We looked at other countries. Here you see Australia. In Canada, this proved actually to be a focal point, particularly the program in Ontario, Canada, very robust, or Alberta, Canada, very robust. We actually had a presentation from the woman that runs that office. Again, an impressive program that we ended up modeling much of our work after. So based on all this review, I didn't include the slide that showed that we also reviewed other state agencies' oversight of trust accounts. So for example, trust accounts that are established in the filmmaking industry, or trust accounts that are established to put on large theater productions, those are audited. If any of you have been in the business of purchasing a funeral plot in advance, those funds are audited annually by the state. So many other funds that are held in trust audited by various state agencies. And the Special Discipline Case Audit Committee took a look at that as well. So with all of this input, here on the screen, you begin to see the parameters for the program that was ultimately adopted. First is an annual registration of all trust accounts. This is really important information for us to have. At this point in time, we have no information about how many trust accounts are out there or what the balances are in those accounts. There is a requirement to report on IOLTA accounts, but as you are aware, that is only a small percentage of, we believe it is only a small percentage of the client trust accounts that are out there. In addition to registration of the trust accounts, there will be a requirement that attorneys certify their compliance with rules and statutes pertaining to CTAs and complete a self-assessment. This is all designed to be educational. Then the next step would be the compliance review. This would be completed on a sample of client trust accounts, and that sample would be selected via a combination of both random and risk assessment-based factors. These compliance reviews would be conducted by CPAs, secured by attorneys, but using forms developed by the state bar. In response to that compliance review, a number of different things could occur. Nothing, a statement of deficiencies and a requirement to correct. The requirement to correct could include educational requirements. An audit could be ordered, or there could be a referral to discipline. Based on what we've seen of the data that is available from other states and other countries internationally, the very small percentage of these cases actually end up being referred to formal discipline. This really is understood to be much more of an education and preventative approach. Another prong to that end of the program that the board adopted is attorney education. So significantly more attorney education around how to effectively manage client trust accounts, and public education to understand what their rights are and to understand what attorneys are in fact required to do. The estimated cost of this program is about $3.35 million annually. This is based on staffing numbers that we've seen in other jurisdictions. And that would allow for about 500 compliance reviews annually. So this is not a huge scope, particularly when you think about the fact that we've got about 200,000 licensed attorneys in California. Statutory and rule authority is needed to implement the program. And I'm going to talk about that in a moment. So what's the timeline? What are we able to do now versus later? So what is contemplated now is that beginning in 2022, the first step is actually the last bullet. We currently have out for public comment rules that will give the state bar the necessary authority to implement the program. Assuming those are effectuated and adopted, but ultimately that is a Supreme Court rule, we would then plan to begin requiring attorneys to register their client trust accounts with the 2023 billing cycle. Along with that registration would be the certificate of compliance and the self-assessment. In this year and into next year, you will see more education and professional development being provided to attorneys free of charge by the state bar, and also very intentional measures around client education. I have mandatory bank reporting here. This is an element of the program that the board recently added. It will require statutory authority to implement. This bank reporting would mirror what banks are currently reporting on the IOLTA side. Some of you may know that not only are attorneys required to provide the state bar with information on their IOLTA accounts, but banks are required to provide the state bar with information on IOLTA accounts. The goal of that really is to look at interest rates paid by banks on IOLTA accounts. But we have asked to expand that bank reporting to all client trust accounts. And then phase 3, the compliance reviews, the risk review and follow-up and the audits is all TBD. Why? Because of that price tag that I identified earlier, and there is not a known funding source. So right now we intend to start with registration, just getting a handle on how many accounts are out there, what is the balances in those accounts, and to begin to do some analytics around trust accounts by practice area, by size of firm. All of that kind of analysis we'll be able to do once we begin to have the data. So as I mentioned, this rule that would give us the implementing authority to establish the program is currently out for public comment. Also out for public comment, clarifications to 2 existing rules of professional conduct. These clarifications were recommendations identified by the Special Discipline Case Audit Committee. This one is an amendment to Rule 1.15 to specify the time frame, a time frame for distribution of client funds held in trust. Right now, there is a promptly notify standard, and that standard is being replaced with a day standard. And you can see some of the elements of the rule proposal here, but this is out for public comment. In addition, we have out for public comment a comment to Rule 1.4 that clarifies that the attorney's responsibility to communicate significant developments to a client is triggered by developments related to the receipt of funds. So both of these out for public comment, and I can tell you that taking a brief glance at the public comment, most of which has been received by attorneys, there's overwhelming opposition, particularly to the amendments to Rule 1.15. So I'm just going to close out with just a brief, overview of what we have now versus what we will have under the Client Trust Account Protection Program. What we have now is a responsive, not a proactive approach to regulation of client trust accounts. This is problematic for many reasons, but for one reason is that we know on the reportable action side that Black male attorneys are 10 times more likely to be the subject of reportable actions. We also know that we are less likely to receive reportable actions in relation to attorneys with greater volumes of business and more money in their trust accounts. So our current approach may be, in fact, a bit regressive. There is also not a meaningful education component in what we are doing now. Under the CTAP program, there's universal registration of trust account information, and there would be a review of accounts, a combination of random and risk-based. And I will tell you from talking to the folks in Ontario, Canada, one risk factor is the amount of money in your account, in your trust account. So this is actually the opposite from, being concerned about getting a reportable action for an overdraft of $50 or $100. It's the opposite kind of risk factor. There are resources for attorneys to support compliance, and there's public education and outreach. And there to the right, you can see the expected outcomes. And this, again, is not sort of just theoretical. We understand this from talking to other jurisdictions that have programs such as this. So that concludes the overview that I was asked to provide of the Client Trust Account Protection Program. Happy to answer any questions or if folks have comment. Hi, Sinead. Go ahead, Sinead.
Thank you. Yeah, good afternoon. I have a quick question. I know you just covered one of the factors as it relates to the compliance reviews, a combo of random sample as well as risk assessment. So what are some of the other factors as it relates to risk assessment? Then I have one more question as it relates to Black attorneys, you know, being the subject of bank reporting. But how will the state bar kind of get in front of appeasing potential fears that minorities and Black males will be, sorry, it was UPS truck. How will the state bar kind of get in front of potential, like I said, fear or that Black males and minorities will be the subject of these random and risk assessment compliance reviews?
Yeah, I know.
Hello. Hi.
Good to see you.
Oh, nice to see you. Yeah, I didn't recognize you with the mask.
I know, you want to mute yourself? Okay, I recognize Sean's voice. So I'm very familiar, Shanae, with that concern, and have enjoyed the one conversation I've been able to have with Cable about that, and look forward to having more. I believe that this process is inherently more fair than what we currently have, because it is going to reach out across all 200,000 active licensees. And our current approach does not. So in terms of the risk factors, there is dollar volume in the trust account. There are the number of trust accounts that you have. There's practice area, and that is information that is gleaned over time. So starting out, we will not necessarily have the benefit of knowing a practice area and its relationship to client trust account violations, but we do know from other jurisdictions, this is consistent in Australia and Canada, for example, that estates and trusts is an area where there's a higher risk factor. So those are the kinds of factors. None of them that I have seen in other jurisdictions associate or are tied to or would lend themselves to having Black male attorneys be more likely to be audited. I'll just say that. So high dollar volume in the trust account, many trust accounts. That is not, that's not my understanding of what the profile in California looks like of the average Black male attorney. But again, we don't really know, because nobody's registered their trust accounts with us yet. So I may be making some assumptions. But that's what I can say now. The risk factors are not fully set or established, and that's something that we would need to work on, and hopefully in partnership with stakeholders.
Thank you, Leah. One more question. So will it be like a pilot program first to kind of test to see how everything goes and possibly work out any kinks, or you guys are just gonna go forward?
Well, first of all, I hope I made it clear. We don't have the funding right now to do the compliance review, which is what you're talking about, where we would identify the sample based on a combination of random and risk-based factors. We don't have that funding. So there's not even a pilot. What we will do initially is simply collect the information about, here are the client trust accounts that I have, and here are the balances in those client trust accounts. That's all we're going to do now. And that is not a pilot. If and when we get funding to do the further analysis, it hasn't necessarily been contemplated as a pilot, no. But we also don't have a projected start date because we don't have funding for that aspect of the work. And I think you may have had a second question. Did I answer both your questions?
Yes, Leah. And then, but just one more last question, everyone. So how will the state bar secure funding? I hope it's not proposing raising bar dues to.
Well, I think, I mean, we certainly haven't proposed that yet, but that is the way that we are funded. So that is the way that it would happen. When I have talked about it, I have posited that this may be the one area where we could have a more progressive fee structure. Right now, we are not allowed, for example, to charge attorneys that make more money higher licensing fees. Okay, we have sliding scale fees, fee waiver for very, very low income attorneys. But in this situation, what I have suggested is attorneys with higher dollar trust accounts Attorneys with more trust accounts, that is more work for the audit program, and therefore, though they would pay a higher fee for this compliance activity than attorneys with fewer trust accounts, lower dollar trust accounts. So creating a progressive fee structure might make sense and be justified in this area, something we are not allowed to do on the licensing fee side. Okay, Judge McGill.
Thanks, Leah. Yeah, I had some concerns just like Shanae had regarding the factors of risk assessment. And also I was curious as to who was going to be paying, because I thought I've been in an earlier presentation, I can't remember where, that one discussion was to charge the attorneys who get selected for the audits, basically to pay for those. And, you know, if you take the amount of money that you were proposing and divide that by 500, that looks like about $7,000 per audit. So that could be kind of pricey for some attorneys, especially those who are in solo practices or don't have as lucrative practices as other attorneys. But I do have one final question. I thought in earlier presentation I'd seen there was some discussion about following, I guess, in other international, somewhere in other countries, that third parties could be retained to hold entrusted funds and attorneys could utilize that. Was there any further discussion on that? Did I recall that correctly as being one of the things going out in other countries? And are we still looking at that possibility for attorneys to use?
You did see that in France. That is the universal model. Local bar associations have their own affiliated banks, and they are managing all of the trust accounts, and that's a requirement. In the UK, there is extensive third-party management of trust accounts. That is not currently allowed under our rules, is my understanding. There is an effort, if you've heard of the regulatory sandbox going on in Utah, there is an initiative that's been approved there under the relaxation of the rules, whereby attorneys can hire essentially an escrow company to manage their trust accounts. So we did look at that. I think the feeling by the committee was that that was such a wholesale and radical change to our current paradigm that it just would not be feasible to recommend at this time. But it has obviously it would have tremendous benefits. And I think many people feel that it's quite an attractive option. So we did look at it, but it's not ultimately the way that the committee decided to land.
I would say that I had actually discussed this with some practicing attorney friends of mine, and that approach actually, surprisingly to me, pretty much across the board, they were all very interested in that because they thought, wow, I don't have to be responsible for this anymore. And they were, it was a surprising response I got from the 3 or 4 people. And obviously that's not a sample of anything, but I just thought that was interesting anecdotally when I was talking to people about that.
Yeah. Eloise and then Jerry.
Thank you, Leah. I was surprised at, did I catch the statistic accurately that you said IOLTA accounts only account for 5% of these client trust accounts?
No, I hope I didn't say that. I said that we think it is a minority, meaning it's not a majority of trust accounts. We do not know though, because we've never required registration of all trust accounts.
Well, I can speak to, you know, as a family law solo practitioner, I'm not a big tort attorney, so I don't deal with $1 million settlements of personal injuries or smoking violation, you know, smoking injuries. I deal with sales, you know, occasionally a sale of a house in a divorce. What I found in one of my cases that I wanted to distinguish between funds that are advanced to me as retainers for my services, from which I then, once the service is given, were provided, then I withdraw that money. My first experience with the state bar was over a slight irregularity of with my IOLTA account, and that's the source of my saying the state bar is my parole board, because I was pretty immediately contacted by the state bar to clarify what funds I put in, what funds I was taking out. So I, got very, very happy with the fact that I still keep a regular checkbook. However, at one point, where I had where a $400,000 equity remained out of a house sale in advance of the judgment in family court over who would get how much. And I didn't want to put that into my IOLTA account because it was not fees for services. So I had to go shop around to 3 different banks to find a product, which is the term they use, for a structure in which I could set up a trust account basically between the two, the husband and the ex-husband and soon to be ex-wife, with me as the guarantor or supervisor, or whatever, the trustee, who would guarantee that once the judgment had been made, then I would be responsible for securing the judgment, presenting that to US Bank, and then distributing the funds. However, after that, I said, banks vary in what the products they will offer. So what I did was open up a second IOLTA account, which I designated with Chase Bank to be exclusively for funds like this, which were real estate or transfer funds from a trust, which were not funds that were payment for my services. So I don't know how this fits into the discussion here, but I just know as a practitioner that banks vary in the products they offer, depending on the branch and the bank itself. So I'd be interested in whether the State Bar would have a program with particular banks to meet that particular distinction between attorney funds deposited in advance, as opposed to funds which really belong to clients and are yet to be divided by a court judgment.
Well, I think it's a great comment. We don't have a program per se, but I will say that as we waded into these waters, I've heard quite a bit about banks and challenges with banks. We are obviously working with or trying to work with the banking industry as we work on the mandatory bank reporting component of this. And so certainly these are issues that we're learning about, and I think the board will need to take up the question of whether we need to do something more affirmative, like identifying the way we do in the IOLTA side. We have leadership banks that agree to pay a certain interest rate on those IOLTA accounts. Would we similarly try to designate banks for their effective or user-friendly processes on the CTA side? It's a question. Jerry?
Thanks, Leah. I'm impressed by the presentation and the report of the board committee. I think often what I know is that some of the states in the US where they have more rigorous trust accounting efforts, including random audits, it arose from something like Girardi. So you have an opportunity right now to do something effective. I think even just the part that you could fund that doesn't involve audits is very useful. I think that I'd be interested in knowing whether you're seeing greater reimbursements for your client protection program, or what the trend has been. And you would hope that the specific and general deterrence from whatever you're doing, whether it's more the educational engagement and data collection or audit, would have some positive effect on client protection losses that have to be reimbursed. Just seems obvious to me. I know that South Africa, I think, takes some of its funding for regulation from its IOLTA money, which would be very different than we do in our country, but it might be something worth thinking about if it means you can get ahead of the losses. So you mentioned the approach in France, and I have a little familiarity with that. I was intrigued by an effort of the Florida bar to create an omnibus trust account process for the entire profession. And they were so close. And they had a bank involved, and they had another partner involved. And they rolled out a pilot. And it didn't work. I don't know why it didn't work. I kept asking John Barry, who was then the bar counsel there. And I think it's, as we get more powerful computers, if there's any chance to do something like that, it relieves particularly the undercapitalized sole practitioners of all the record keeping that really, all that does is support proof that the balance in the account is equal to the totals of clients to which money is owed. So it's just that simple, but it's not simple to do. And if there's any interest in there, I think the Florida bar has some good information on it. But I just kind of going back to my first reaction is, even the part you can fund now is a good response to the real challenge that the Girardi circumstance and the audit, your auditor's report in terms of efficacy of investigation of trust accounting. This is really something that I think is important for the bar to get behind and do something. And you'd like to think audits, but maybe it's not time for audits. Audits are, I mean, in New Jersey, they say this is exactly what you said, Leah. It's educational. 1% or so are produce evidence of defalcation, or 2 or 3%. This is and it's hard to get lawyers to see it that way. And you have algorithms to screen out overrepresentation in minority, in selection of individuals who would have to do the audit. So I just think it's all kudos on a wonderful report.
That's a great point. And I should have mentioned that in response to you, Sinead, that there are lots of ways to ensure that your sample is not over sampling certain groups. So even if the risk and random gives you some kind of disproportionate sample, say oversampling of black male tours, you can adjust it at any time based on sort of an equity factor. And so that is exactly the kind of thing that we have talked about doing. I also wanted to clarify, Judge McGill, the 3.5 million would not be borne by the 500 attorneys. So the way that this would be funded, that 3.5 million that you saw would be an additional assessment across all licensees. I think it amounts to about $20 or $30 if you did it equally. When we have talked about it, we talked about it again as the progressive fee structure. So you would not charge all attorneys the same amount. But those compliance reviews, if they are directed, and an audit, if it is directed, that would be borne by the individual attorney. And the cost we've gotten on that is about $2,500.
Oh, okay. All right. Well, thanks for those clarifications, Leah.
I wanted to make sure to do that. Janet?
Hi there. Thank you. I wanted to just make a couple comments and had a couple questions, but I do, Leah, agree with the online education. I think that's good and preventative. I was curious, I didn't hear, and I read on the Vargas report that it was recommended to encourage the attorneys to rely on the systems and systems of professions and technologies to prevent the trust accounting errors. I think from what I'm hearing of the prior people, and I think last time I brought a quote escrow company idea up, it was too progressive. I was wondering, I know it's not under the current rules, but it seems like such a fantastic business idea. If the state bar isn't going to create that accounting solution for the client trust funds, then maybe allow private resources to allow it. And my other comment was, or question, how many public complaints are received each year from the public or regarding trust funds?
We had that data, and I don't know, Steve, if you recall it off the top, we pulled that together for the Special Discipline Case Audit Committee. We also have it recently, George, from the audit. I want to say it's about 1,500 a year, 2,000.
So
I was going to say, I think the number is between 1,500 and 2,000 a year.
okay.
For
For the public, yeah.
So I think it's also important to note that sometimes these complaints don't come in as a complaint about the handling of a client trust account. Sometimes they come in as, you know, the attorney is not contacting me or not returning my call, and it may be that the attorney received the funds earlier and hasn't paid out, or and the client may not even know that the attorney has received money, or maybe they've found out that they've received the money and they just said, well, they haven't sent me a check, but it's not necessarily a complaint about attorney, client trust fund accounting issues.
Okay, thank you. That makes sense. But as a part of the public, I would, if I were to choose whether somebody followed up on my complaint or if there were going to be random audits, I would definitely choose that. I would hope that they would pursue my complaint, because there might be a possible problem with that attorney. Random is random. And I'm sure there's a lot of errors in any business with accounting. But again, the whole purpose is to help provide confidence in the public and misconduct. And that would be something I'd prefer to have followed up rather than random audits and costing attorneys more money and time and take away. Thank you very much.
Oh, thank you. And I was going to encourage, as I indicated, the public comment period on the 3 rules is still open. And your comment, Janet, about the escrow account, I think it would be great to receive that kind of public comment. As I said, it would require a significant rule change or authorization for an exception to the rule. It's very similar. It is the conversation happening as part of the regulatory reform discussions that are underway. And there is an existing model that's been authorized in Utah. I think that program is called Zera Connect under its regulatory sandbox. Any other questions or comments? I can't see everybody, Justin, I don't think, but.
I don't see any hands raised.
Okay, great, thank you.
All right, great, thank you so much, Leah. And for everyone who discussed this, I think we got some really valuable feedback and some great ideas, so thank you. I do want to go back to public comments. Justin has informed me that it looks like there's one person who would like to address the board. So Justin, if you could identify that person and then give them 3 minutes, please.
Sure. It's NC Carlson. I have granted you access to talk. So if you unmute your
microphone.
I
did. Should I do it through the computer or phone?
Only one, because right now we're hearing an echo. You can.
Great. Can you hear me?
Yes.
Oh, terrific. Great. I'm saving minutes on my Sprinter, whatever, T-Mobile, whoever cell phone service. I've had it on the whole time for the meeting. I was just emailing Justin to say, I'm trying to get a hold of you. So hello, everybody. Thank you for your work. I really want to see the state bar function. I'm a member of the public. I've actually kind of formed a little committee outside here in the layperson's world, which we call the consumer bar. We're trying to put things and recommendations together for your committee and for the OCTC and OGC, but basically for the state bar regarding rules and regulations. And like many people, you get interested in something when something's happened to you. I have my experience with the State Bar, and I'll try and be very succinct, goes back to starting in 2000, where I had requested an MFA regarding fees. It was a high profile attorney. And just like you just said, it suddenly involved a discovery of a lot of trust misconduct. I had set up a non-IOLTA trust, et cetera, and we discovered that he had started moving money and that was coming in from me routinely into accounts of his own, et cetera, et cetera. But the MFA started in 2000, and here's one of the issues. There wasn't a hearing until 2005. At the conclusion of it, with the misconduct that the judge found, so on and so forth, the State Bar director at the time, Jill Sperber, actually wrote us and said, you need to file an ethics complaint. He did. That sat and languished and languished. And I will say that we put together, before I even wanted to do that, I took the time to be sure about this, because a high profile attorney, litigator, and you know, litigators like to throw paper at everybody, had a former State Bar prosecutor, a law professor, two attorneys who ultimately successfully prosecuted this attorney in a client class action against him for similar misconduct successfully. We submitted those reports also, but we put together a very organized brief, complaint, and notebook volumes of evidence for the OCTC. And that just sat at the bar, and it kept getting kind of sort of tossed around. And then we
You
got
have
it.
30 seconds left.
So we need to see these things get processed and be handed to the right people. A complex case, a high profile attorney, this is a very Girardi-like case, needs to be given to not a rookie lay investigator. And it needs to be taken seriously. That's a frustrating thing for the public. And when you have something pending at the State Bar where your money is tied up for years, that's a very painful process to be experiencing as an individual.
Your time is up. Thank you.
All right. Thank you so much for your public comment. We are going to go down to item B, which is overview of the 2022 state audit and state bar response. And George Cardona is going to be leading this discussion. So welcome.
Hi, thanks. I'll go through state audit findings and what we're doing in response. So let me share my screen. Okay, so hopefully you can all see that now. So you have the state audit report as an attachment to the agenda is provided. And for those of you who have read it, I think we will all agree that in there are some troubling findings, particularly with respect to some of the case examples that they went through in terms of that, and they arrived at a series of recommendations. As indicated in our response, which is attached at the end of the state audit, we agree with the overwhelming majority of those recommendations, and we're actually already working to implement them. So let me take you through those and give you. So their recommendations can be grouped into kind of 4 categories. There were a series of recommendations relating to investigations and case closures. Some recommendations regarding how we handle conflicts of interest, both identifying them and making sure that we check them at appropriate times during the case before actions are taken. Some recommendations regarding our external audit process. We do semi-annual audits of a random sample of our closed cases to ensure compliance with our policies and procedures in closing, and also to ensure that we're not closing cases that it's unreasonable to close. And then there was a series of recommendations relating to client trust account violation complaints and bank reportable actions, kind of the subject of what Leah talked about on the client trust account protection program. This would be on the discipline side of that. So I can walk through these. As I indicated, we agree with most of them and are already working on them. So first, this is a recommendation from the auditor that we implement a tighter policy that maintains more specific criteria on when we should or should not be using non-public measures to close complaints. That is, non-public measures being alternatives to discipline such as warning letters and or private reprovals, true private reprovals that are issued prior to the filing of a notice of disciplinary charges. And the recommendation was we should revise our policies to define specific criteria for which which cases are eligible to be closed using non-public measures and which are not eligible. So we will be doing that. We'll be putting together policies and procedures, laying out specific criteria both for eligibility and for exercising discretion to apply these types of non-public measures when they are eligible. We expect to be doing that in the near future. So that's the first recommendation. Second recommendation was with respect to complaints where the complainant subsequently files a complaint with the state bar, but subsequently advises the state bar that they wish to withdraw that complaint or that they don't wish to cooperate with the investigation or prosecution of that complaint. And the recommendation was, after some findings, they found cases where they believed that we had closed simply based on the withdrawal. Recommendation was that we put in place a policy to address this. We've already done that. We put in place a policy in February of this year to make clear that simply because a complainant withdraws their complaint doesn't mean that we should close it. In other words, we have an independent obligation to continue to look at that case if the evidence supports us moving forward with investigation. And this is important because this was actually a spin out of Girardi. A suggestion in some of Girardi's cases that after the person filed the complaint and the person then withdrew, a suggestion that Girardi had worked out an agreement to basically get them to withdraw their complaints and try and get the investigation stopped. So we've put that policy in place. We'll be working on procedures to ensure that we monitor it and make sure that that in fact happens. That cases are not closed simply because a complainant withdraws their complaint, that there is kind of an independent evaluation of the evidence to determine whether there is a basis for continuing with the investigation, despite the fact that the complainant won't be cooperating. The third recommendation related to discipline in other jurisdictions. We can pursue discipline in our state based on discipline by other jurisdictions, including other state bar disciplinary actions in other states under certain circumstances. And typically we can't file a notice of disciplinary charges based on the disciplinary action in the other state until that disciplinary action is final. This caused a concern to the auditors that there's a period of time when there is discipline pending or some interim action, for example, an interim suspension in the other jurisdiction based on a finding in the other jurisdiction that the attorney poses harm, when we have not yet proceeded with the notice of disciplinary charges and the public here is not on notice. So there was a suggestion we should notify the public on the website when other jurisdictions determine that an attorney licensed in California presents a substantial threat of harm. We agree with that recommendation, and indeed there's going to be an item on the agenda for the board in May suggesting a consumer alert to be posted on the attorney's webpage with appropriate disclaimers when in fact there are certain types of disciplinary actions, even if they're interim, in other jurisdictions that we learn about. The fourth recommendation also related to discipline in other jurisdictions and was basically a recommendation that we use the ABA's, the American Bar Association's data bank to identify attorneys disciplined in other jurisdictions. We've actually taken care of this. We have access, and we've also implemented procedures to ensure that we get notice from that database when a California attorney is subject to discipline somewhere else. Patterns of similar complaints. The recommendation was, and again, this spins from the Girardi situation where Mr. Girardi was the subject of a whole series of complaints over a significant period of time. The suggestion was that we should be looking at those patterns of closed complaints to attempt to see if there's some pattern that suggests we should take a more close look at a current complaint, or if we should go back and potentially reopen some of the older complaints based on a pattern. So the recommendation was to allow us to do that, to see those patterns. We should use a categorization system. Right now, they're in our case management system under somewhere between 600 and 700 different charges, which are the specific charges. We have a categorization of those into certain groups that's been developed, and we're going to begin using that to more easily try and identify patterns. So to see if a particular attorney has a series of complaints within a particular category, that leads us to believe we should take a closer look at a complaint. We're already doing this. Importantly, this will not alter the previously adopted policy to archive complaints that are more than 5 years old. One of the actions that was adopted in response to the FARCUS study was to archive complaints that are 5 years, more than 5 years old, to avoid potential disparities and are looking at closed complaints. So that will remain in place, but we are going to do this categorization. So that takes care of the investigation and case closure recommendations. There were then a series of recommendations relating to conflicts of interest. The long and the short of it is we agreed with these. There were recommendations that we should implement policies and procedures both to identify conflicts and to make sure that those conflicts are being checked. We're in the process of putting that in place, a new policy and some new procedures, including some modifications to our case management system to ensure that we not only have that, but that we have a record of when those conflict checks are done. The next set of recommendations related to our external audit process. As I mentioned, every 6 months, we do a random audit, an audit of a randomly selected group of closed cases to ensure that we're complying with policies and procedures. The recommendations basically related to ensuring the independence and objectivity of that outside auditor. So requiring that that external auditor have some role in the selection of the cases, which is random, but have them oversee that. And then to make sure that we follow up on that to establish oversight to ensure that we report back to the board on what we have done to respond to the auditor's suggestions. And so we are implementing policies and procedures to do that. We agree with that, and that should be done subject to potentially some extra resources that will be needed, and I'll talk about that at the end. So the final group of recommendations related to CTA violations, client trust account violations, and bank reportable actions. And on these, while we agreed with the kind of the sense of the recommendations, again, stemming from the Girardi situation, that we need to tighten up our oversight of client trust accounts to ensure that something like Girardi doesn't happen again. While we agreed with kind of the sense of that, we had some disagreements as to how exactly to do that. And so I'll walk through some of these. So with respect to bank reportable actions, we have in place policies and procedures under which, with respect to some of those that are de minimis, and in particular, where we get a bank reportable action, that is a report from a bank that there's been an insufficient funds transaction on a client trust account, where that amount is minimal, where it's less than $50, which is how we define de minimis, where it's less than $50, there are instances where we will simply close that. In particular, if there's nothing else that suggests that there's something going on, if we just get a de minimis, we will likely close the first one, and then we take progressive action as others come in. Their suggestion, their second one, was that we revise our intake manual to disallow de minimis closures if the attorney has a pending or prior bank reportable action or a case alleging a client trust account violation. We disagree with that as a blanket policy, in part based on equity concerns and what Leah mentioned, which is the data showing that Black male attorneys tend to get much higher, 10 times the number of reportable actions from banks as white male attorneys. And so for both equity concerns and for what we believe is a more efficient use of resources, we are not going to take that blanket approach, but are going to craft a new policy that outlines criteria for when de minimis closures should occur and when they shouldn't, trying to set out criteria that will not allow that type of routine closure if there are circumstances that suggest that there is something that needs to be looked at, but allowing it if there aren't such circumstances. The next set of recommendations was similar with respect to non-de minimis bank reportable actions, that is, reportable actions over $50, and complaints about client trust account discrepancies. And this was that when investigating those types of cases, we require our staff in all of those to obtain both bank statements and the attorney's reconciliation, and then do analysis to determine if the relevant transactions are appropriate. Again, this is a tightening up, and while we agree that there needs to be tightening up, we don't agree with kind of that blanket approach and doing this in all cases. We don't think that would be an efficient use of resources. And again, we are concerned about the equity concerns that this might, if we do it as a blanket matter, might inappropriately, again, for the same reasons, result in us doing more of these on black male attorneys as opposed to other attorneys. And it does incur costs on those attorneys because they would have to respond and participate in the investigation, which would be open in every case. So rather than that, we're going to be drafting, again, a new policy that lays out specific criteria defining the situations in which this type of analysis needs to be done, so that we try to focus our resources on the cases where there are indicia that there's something that needs to be investigated, but tighten those criteria up as opposed to simply doing it as a blanket matter. The final recommendation was that when we close one of these types of investigations, we send a letter to the attorney with an advisal of resources available to assist in managing client trust accounts. And we agree with that, and we'll be doing that and modifying our closing letters so that we do provide those types of resources, kind of the educational piece that Leah talked about at length. This is kind of a first step in that, adding those advisals as to what resources are available to our closing letters. So that's a quick summary of the recommendations and our response. This last slide, basically, I just wanted to convey to everybody that we are on a tight timeline to do all of this. The audit itself, we've already done some things. Most of the audit's recommendations, they wanted done by July of 2022. A couple of them, they provided later dates of October and April. For some of those, if you look at our response to the state audit that's in your package, you'll see that we identified situations where we believed additional resources over and above what we have would be needed. And I've highlighted here the recommendations that where we believed additional resources would be needed. That remains an ongoing question as to where we're going to get those additional resources to, for example, implement additional monitoring, which will take additional people and additional time. And in some situations, make changes to our case management system and our computerized systems of records that will also require some resources. So we're still looking at how and where to get those resources to make those changes, but wanted to emphasize the tight time frame we're on for making some of these policy changes and some of the procedural changes to implement the recommendations. And with that, I am going to turn it back, and I'm happy to take any questions.
All right, does anybody have any questions for George? And sorry, I cannot see.
Yeah, let me stop sharing.
Yep.
Okay.
All right, anybody have any questions for George? All right, Ms. King.
Thank you. I just wanted to ask about the cushion. Are you going to consider increasing the cushion?
You mean what we classify as de minimis?
Yes. And
no, not right now. There is no plan to change that away from the $50 as to what it is now. That was the subject. There was a presentation to the board on that in the past, and there was a decision not to modify that at that time.
do you know why? It just seems like, reading the Farkas report and all the research I've done, it seems like it would alleviate a lot of issues.
Yeah, it's we'd have to look at the numbers to see what changes in the cushion in that de minimis amount, how many bank reportable actions would fall within it. But there, the state audit has some information in there suggesting that even the $50 de minimis amount is an appropriate amount, because there have been a number of cases where a $50 de minimis bank reportable action has in fact been the precursor to a subsequent determination that there was some misappropriation of funds. So it would be a balancing between those two.
Thank you.
It wasn't done specifically because there was this analysis presented to the board, I think of 10 or 20 years worth of reportable action data that did show, as George indicated, that even for those low dollar amount violations, there was ultimately discipline. that they, they were substantiated. So that's why the board did not decide to raise the threshold.
Okay, thank you.
Yeah, and staff can correct me if I'm wrong, but my recollection is that the lower number, or the lower number actually was a greater indicator that there's some sort of misconduct going on. And so it almost seemed counterintuitive when we first approached the situation, but a study of the various cases showed that the less the amounts that was, I guess that the account was being paid for, showed that there's actually a greater likelihood of misconduct. So that's what's stuck in my mind. And Melanie and Steve, I don't know if you remember the exact numbers on that.
I don't, sorry.
My recollection from reading the report was that it was a comparison between 50 and 100, and the 50 was more indicative than the 100, but I may be wrong.
We can provide that to the group. The agenda item that outlines that.
All right, thank you. Any other questions for George?
All right, I don't see any, and I think it's just important to highlight that the auditor's recommendations are really, something that the State Bar takes seriously. It's something that, as you can see, staff has spent a lot of time and resources on implementing, and with this timetable that's been set up, definitely requires some prompt action to be taken. And we thought it was important to bring this to the commission so the commission could understand what we're hearing from the state auditor and from their office as to how we can improve the discipline system and steps that need to be taken in the short term and long term. So because these recommendations touch on a lot of the discussions that we've had, we really wanted to be able to get that information in front of you so you understand what our stakeholders are telling us and what actions we're taking because of that immediacy. So anybody have any questions about that or discussion?
I was just going to add that, when I reviewed the commission work plan or some of the, I guess, the working groups and their focus and the audit, I was struck by two areas in particular. One is the conversation that the ad hoc commission has had, or one of its working groups, around notifying respondents whenever a complaint has been received. And I think there have been some concerns about doing that. But you see now in the audit, there is a direct recommendation that happen with respect to a subset of complaints. And we've agreed that we are going to do that, in fact. So there's a nice nexus between something that the commission has considered and what has been recommended now by the state auditor and what we are agreeing to do. So I think that's an important fact to lift up. And then the other has to do with the use of non-public discipline and the diversion conversation that the commission has been having. Non-public discipline, not particularly well received in the audit. I did ask them about, just suggesting that we eliminate it as an option altogether. They did not do that, but they discourage non-public discipline and want us to tighten up our criteria for non-public discipline. And so in thinking about whether or not expanding diversionary alternatives is viable for us as an organization right now, I think the audit is instructive. So those are kind of the 2 points that I would elevate, Brandon. And I see
Thank you, Leah.
Jerry has his hand up. I don't know if you can see that.
Yes, Jerry, go ahead.
Thanks. I do applaud the efforts and the quick turnaround on efforts. What I've seen in other state disciplinary mechanisms are efforts to follow up on diversions that don't work. So for a diversion for that to happen, one has to have requirements, conditions that are either proved successful or not. And if not, there has to be some response. Otherwise, the diversion programs don't work. I've seen in other jurisdictions, and not Illinois, where I'm from, a real focus on what the lawyer who's called a frequent flyer in slang, someone who has lots of grievances. And at some point, whatever the criteria it is, it bears a much more hands-on approach engaging that lawyer. It doesn't mean disciplining that lawyer. It means catching that lawyer's attention, engaging that lawyer, helping that lawyer to provide a basis to fix whatever problems, if there are problems, cause that lawyer to receive so many grievances. And that seemed, the audit report focused on a couple, at least, of those examples. So I just share that. And it's very similar to what you're doing a little bit is you're devoting resources, scarce resources at the front end to engage lawyers more. And I just applaud that effort. I think it pays off. So even reportable actions where the Farkas report shows an overrepresentation of Black male lawyers, the right touch actually can provide, particularly in the lower level insufficient funds checks, that lawyer with guidance to avoid the next several. Most of these efforts that we're talking about require fronting resources, engaging lawyers, and giving that lawyer tools and the motivation to avoid the downstream activities and complaints. So I know there are balance issues here, there are resources issues here. I applaud what you're doing, and I think you're going down that path a bit. And you know, the scale and scope of the California system is beyond my mere comprehension. So I just share my comments. It does work though, the engagement. So I hope that you see that payoff in what you're doing. Thank you.
All right, thanks, Jerry. That's encouraging to hear. All right, any other questions or comments or discussion?
And Brandon, I think this is an appropriate time to, because I had asked you to take the two working group kind of updates out of order, and Leah kind of teed off the conversation that I wanted to have on the diversion working group and the closed complaints notification working group. So if I can just kind of jump into that now, if you don't mind.
Definitely, go ahead.
So with the recommendation 1 that George put up on the screen, they are taking a look at the non-public measures. And so that was a specific area where the diversion working group was looking at. They were kind of investigating the use of the non-public measures and whether or not it was appropriate. Well, as George said, they are revising the policies and procedures. So what was presented to the working group back when it was initially done is going to be different than what ultimately comes out from the recommendations for the audit. So this is a working group where I'm not sure that it needs to continue because there are changes and revisions being made now because of the audit. So in terms of what the charter of this working group was to look at those non-diversionary measures. Initially, the subcommittee looked at maybe creating a different alternative discipline program or enhancing the alternative discipline program, and they decided not to make any recommendations or pursue those, but they did want to look at the non-discipline measures. And since the audit has addressed those and they are making changes now, I don't know that it makes sense for the working group to continue to meet on something that is changing. And I just wanted to kind of propose that to the commission, if it was okay to let this working group sunset, or if they had thoughts and ideas on it. I wanted to bring that to everybody's attention and get the pulse of the commission.
All right. Anybody wish to weigh in on this? All right, Mr. Saleg.
I think Justin's suggestion makes sense.
right, thank you. All right.
Okay.
I would join in Sean's sentiments. I'll be brief, but and I think that's in the direction. So any further direction you need on that, Justin?
If there's no objection to that, since the changes are being made, I will consider that group and focus our resources and attention on the other working groups.
Any strong objection? Speak now or forever hold your peace.
Okay. And then I also wanted to talk about closed complaints for the kind of similar reasons. The closed complaints working group met a couple of times, and there was the two issues were whether or not it was useful to notify the attorneys of the closed complaints and balancing that with resources, because we get, 15 to 17,000 complaints a year. And so notifying everyone would probably create more work because there'd be more questions, more calls, more everything. And so it was just about a resource issue and balancing whether or not it was an effective use of resources and productive for the attorney to receive this complaint. And so we met a couple of times. The audit kind of took a look at that, and in certain circumstances, it is notifying those attorneys of those complaints. George gave the presentation on that. And so this is another area where it looks like we're taking steps to notify attorneys of complaints. That working group was trying to identify areas where it made sense, looking for patterns and things. It looks like the audit is really asking OCTC to look for patterns and things. And so kind of where the recommendations were headed, the audit almost superseded those recommendations and has instructed OCTC to take some initial steps on notifying respondents of those complaints. And so this is another area where I'm asking, is there outstanding issues that this working group would like to continue to address, or is this another area where the audit just kind of took this and ran with it, and we're satisfied with the preliminary steps that it's taking and notification and looking for patterns, and this working group can sunset too? Eloise.
When we've had, thank you, Justin, when we've had a review of reports and the crushing load that comes into the State Bar every year, what I remember flagging was that in some cases where the State Bar decides to take no action, no letter is sent to the person who was complained about. Is that still, kind of a way to reduce the load, or does every person who is complained about receive notification of the status of the final status of their of the complaint, of the processing?
So I'll try and answer that, and Steve and Melanie can correct me if I'm wrong, but the answer is no, we don't notify everybody. If a complaint is closed prior to moving to investigation and us giving notice to the attorney who's being complained against that they need to respond to our questions, if it's closed prior to that, we don't notify the attorney of the complaint. In other words, if we close a complaint in intake based on a determination, for example, that the complaint simply doesn't allege facts sufficient to make out a complaint, then we don't notify the attorney of that. The change we will be making is that for client trust account complaints and for bank reportable actions, we will be notifying the attorney along with providing them with a list of resources that they can use to assist in managing their client trust accounts. And that letter will essentially say, pursuant to State Bar policy, we're providing you with this list of resources. We're not proceeding with any discipline. We'll have to work out the wording, but that'll be that. For other types of complaints, we are not going to be changing our system, except in some instances, if we do see patterns of complaints, we may be doing something along the lines of what Mr. Larkin suggested, is in certain cases where we believe there's a pattern that warrants us sending something out to advise them, look, we're not taking discipline, but we've got a series of complaints that suggest you may want to do certain things to make sure that there's nothing wrong. We may be sending those out as well, but that would be a very limited set of attorneys.
So if nothing, so there are cases in which somebody writes in a complaint and then the State Bar determines that there isn't a basis for any action taking. And so sometime within a 6 month to a year period, you know, that just sort of like goes off grid.
Yes, and the attorney would not have a notice. The complaining witness would. We always notify the complaining witness because we have a statutory obligation to notify the the
Okay.
complainant what we do. So they would be aware that their complaint has been closed.
Thank you very much.
Ms. Buffington.
I have a quick question. Thank you. But aren't those closed complaints, aren't those used if subsequent complaints are filed? Don't you guys go back to see how many complaints have been filed, regardless if they've been closed or not, to determine future disciplinary action?
So we go back. So we go back 5 years. We don't go back further than 5 years. So complaints that have been closed more than 5 years. So we get a complaint. The person who is evaluating that complaint will have access to complaints that have been closed with up to 5 years before that complaint. After that, they're archived. Within those 5 years, yes, our attorneys will look at the closed complaints to see if there is some pattern there that suggests that they should pay special attention to the current complaint. Now, just because someone has closed complaints doesn't justify us going forward on a new complaint. We have to make a determination that the new complaint actually alleges facts sufficient, but it might be something that would trigger, you know, maybe this is something that we should forward to investigations to look at because they've had so many similar complaints over the last 5 years. Does that answer?
Yes, it does. Thank you.
All right, any other questions or comments? Okay, Mr. Moad.
Thank you. I would just highlight that one of the things that the group talked about, and maybe Sarah is, if she's available, can speak to it. One of the things that we talked about was that there are some downsides to notifying the attorneys on every complaint. Not only did we have a concern about OCTC resources, given the number of complaints that we get, and then you know, the attorney wanting to respond, but there's also actual downsides for you know, I believe that there was some discussion of malpractice insurance, notifying the insurance company that they've received complaints, et cetera. And so there, you know, in addition to resources, there's some other reasons that we may not want to go down that road. Was potentially unfair to those attorneys just because they'd received a complaint.
All right, now Mr. Slegg.
Yeah, Steve, your memory is right. So that's one concern about notifying the attorney of these complaints, because then the attorney knows about them. And so in the every year renewal process for professional liability, they would have to disclose them. And there are other situations too where they might have to disclose them. There is at least one exception, which is for judicial applications. Obviously, the attorney can't list a complaint that the attorney doesn't know about, but the Jenny Commission does have access to these complaints that were never shared with the attorney. And there's one or two other situations like that too, but they're all for government functions, not for private parties.
All right, thank you. All right, and then keeping with the spirit of Justin's previous comments about the other item, are there any strong objections to allowing this group to sunset and to continue on with the work that the State Bar is already undertaking? All right, I saw a okay from Ms. Rosenblatt and no injurious signs from anybody else. So I think, Justin, we're good to go on that.
Okay.
Okay, moving on to, actually, you know what, let's do a time check. We've been going for about an hour and a half. Any strong objections to taking a 10-minute break? All right, we'll take a 10-minute break and we'll see everybody back at approximately 1:40. So enjoy, and we'll see you in a few. All right, it looks like we have a majority of the individuals back from break. Hopefully. All right, so Justin, can you take us to the next item of the agenda?
Sure. The next item we're going to discuss is on discipline costs, and the discipline cost working group met a couple of times and discussed things. It was challenging to get them together to meet, and so I'm bringing these. The themes of the recommendations were discussed and and they were developed at those working group meetings, but the actual formation of the recommendations did not happen. And so I'm bringing it to the full ad hoc commission to try and formulate these recommendations with the idea that, these recommendations can be, they don't have to be specific costs, but they can be general in what they recommend to the Board of Trustees on discipline costs. And so in doing so, I will provide a brief overview. The idea of having the working groups is they get into the details. We had several meetings on it, and then we'll bring a high overview to the commission to bring the commission up to speed, and then discuss the potential issues with the discipline costs and the sanctions, and then hopefully take a straw poll and see where people are at on these types of recommendations. So I will begin to share my screen. All right, can everybody see my screen? Okay, so the goal is to determine if the commission supports a reduction in the discipline costs and greater discretion for their imposition. And I'll go into why we think that, or the working group thought that, and then determine if the commission supports the elimination of sanctions. Business and Professions Code 6086.10 talks about the discipline costs and that the charges need to be reasonable cost of investigation, hearing, and review. And so this is what sets forth the costs. The statute was passed in 1986. It originally said average costs, but was changed to reasonable costs. The intent was to grant the state bar greater ability to collect costs. We had this statute reviewed by our Office of General Counsel, who gave an opinion that the reasonable costs to be changed did not require a statute change, that it is within the bar's discretion to change these costs to what the bar determines as reasonable. And so we did have that opinion. An idea of the current costs, they were based on a discipline cost study that was done in 2010. And it was basically a time study of how much OCTC and state bar court time was used to perform discipline. Since that time study, it has gone up every year because they've tied the discipline costs to inflation, the consumer price index. The budget for discipline costs in 2022 is 1.5 million. In 2021, we collected about 1.5 million. Just showing that the amount of costs collected as compared to the budget for the Office of Chief Trial Counsel and State Bar Court, we collected 1.5 million, and the two budgets combined for 75.8 million. So it's a very small percentage. These are the actual costs themselves. There are two columns there: original proceedings and criminal conviction referrals. So the costs are slightly different on original proceedings, which are most likely complaints that are received from the public, whereas criminal conviction referrals are referrals that we receive from the courts on conviction matters. You will see as you go along through this process that the costs increase significantly. And where it jumps even higher is the change from one-day trial to multi-day trial. You can see the costs go up more than double in both of the columns. And then if you proceed to review, you see the costs go up again. The working group looked at what other states reported, and a summary of those other states were 16 states responded to our survey as to what they charge for discipline costs. 2 of them didn't assess costs or fees. Most of the states recouped minimal costs, copying reports or slight investigative costs, those types of things. They were less than 3,000 for most of the other states. Was what was assessed. We also looked at other state agencies within the Department of Consumer Affairs, and administrative law judges make a good faith estimate of the costs in a lot of different agencies, other health regulatory agencies, and they provide those costs. Those costs are then sent to the different boards for review. Those costs cannot be increased, but they can be reduced or eliminated if the board sees fit. So that's other agencies within the Department of Consumer Affairs. The concerns about discipline costs that ADDC and the Association of Discipline Defense Counsel, of which 2 members of the commission are not here today, Ms. Pansky and Mr. Lear, but I wanted to present what they would be saying if they were here. Is an overall concern about fairness. They state that the amount of the costs respondents to settle rather than continue on trial because they can't afford it. Some other things about fairness is if multiple charges are dismissed, the full recovery of costs is imposed. So if an attorney is charged with 10 allegations, 9 are dismissed at trial, but 1 is found guilty, the full cost is imposed. And the argument is that if they were only charged with that initial 1, they might have settled at a stipulation much earlier on and not incurred the going through a multi-day trial. And then also by going to the review department, even if the respondent is able to get a lower level of discipline through the review process, they still pay the higher review cost. And so you win, but you still lose is what they claim. So that is kind of a high overview of the discipline costs. And the question for this commission, and hopefully we will have a robust discussion now, is, does the ad hoc commission on the discipline system recommend that discipline costs be revised or lowered? And then does the ad hoc commission on the discipline system recommend that judges be granted greater discretion in administering those costs? So with those 2 questions and that overview, I now want to open it up to anybody on the committee, Judge McGill, thank you, to give their perspective, and then also to all the commission members if they have thoughts on the discipline cost issue.
Thank you, Justin. First of all, I want to commend Justin for a really good presentation, especially I think presenting the views of Ms. Pansky and Mr. Lear if they were here. And part of our problem was trying to get everybody involved. I think our last meeting, we did not get a quorum, but we still had, I think, a pretty good discussion between me, Melanie, and Steve on kind of where we should go on this. One thing I do want to add factually to the discussion is that you can see that from the costs that Justin shared, going to the review department is about an additional $4,000 in cost, but that's not really the full bill. In order for a respondent to even proceed with an appeal, a respondent has to, well, the appealing party, I guess I should say, the appealing party has to pay for transcript costs. And that can, for a full day transcript, that can run about, I guess about $500. So if you have a multi-day trial, 6, 7, 8 day trial, that could be quite a large transcript cost that the appealing party has to provide just to get the appeal going. So you can add on that to the potential costs that Justin has gone over. Now, of course, if OCTC is the appealing party, then of course the respondent does not assess those costs, or if there are 2 appeals from both sides, then the respondent is only responsible for half those costs. But keep in mind that it seems lately most appeals have been by respondents, and those at cost are necessary. And a number of respondents do at least request additional time to put the funds together because they don't have them. So just to show you the additional financial issues that are involved beyond what Justin had said. So I'll end on that just to give you a more full scope of the record.
Thank you, Judge Miguel. Eloise.
Thanks, Justin. That was really very clear. I'm going to speak just from the point of view of what judges have jurisdiction to do or have authority to do in family law cases. I mean, it's just just presumed, and it's a matter of practice that judges have discretion to assign sanctions, to assign, costs claimed by one side against the other. I mean, I would argue that judges in the state bar court should be granted the same or be assured the same authority that they have in state superior court. Because there's a matter of, in some family law cases, there's an actual requirement that the judge first, as part of this giving a 271 sanction where there's been interference with settlement, the judge has to take account of and make an account or have reviewed the financial status of each party. So some sanctions are given simply for bad behavior, but some sanctions and some as distinct from assignments of costs. So costs and sanctions are two different matters, but in both cases, the judge retains discretion. Some are mandatory, depending on the nature of the sanction. Some costs are simply reviewed by the judge against a list in the Code of Civil Procedure against which costs are allowable to be reimbursed. So I think the judge, I would argue that the judge needs to retain discretion to assign costs, sometimes reduce costs, sometimes increase them for one side or the other.
Thank you, Eloise. Sean.
Yeah, so I certainly support changing how this is handled. The current structure really leads to some very unfair outcomes and really does penalize respondents for going to trial or pursuing an appeal. And the memo, explains some of the anomalies of that approach, that the respondent is still assessed costs for the review department procedure, even if it's successful in reducing the level of discipline. So that just seems really fundamentally unfair. And, I haven't said this before, but I'm going to say it, that many, many years ago, I attended an early neutral evaluation conference before a state bar court judge who's no longer on that court. And he basically gave a lecture to my client that included a discussion of these costs and how the costs get more expensive the farther along you go in the process. And it was kind of, for those of you who like Star Trek, it was kind of a resistance is futile message, which I just was kind of shocked by, to be honest. I didn't think it was appropriate. But it reflects the reality of how this tiered system works. So I'm not sure exactly what we should do to replace it, but I think we do need to give the hearing judge some discretion, and or the review department some discretion. For example, if the case goes to trial, and as I know has happened in one case I handled many, many years ago, that there were, say, 12 charges against the attorney, some of them very, very serious, like moral turpitude. And the attorney ultimately was found not culpable on all of the serious charges and culpable on just a few very minor charges, which made the difference between, say, a 6-month actual suspension and a private reproval, I think was the ultimate outcome of that case. In that situation, the respondent is still assessed the cost. It doesn't matter what the outcome is or whether the respondent was fully justified in going to trial because the respondent prevailed in large part. Just Justin, are we just discussing the cost now or sanctions too? Did you want to break it into two parts?
Yeah, I was just trying to break it into two parts.
Yeah, okay, so got it. So that's my view. But I think we do have this statute, and so we need to figure out what a better approach would be. But I think at least part of that is giving discretion to the hearing judge to make an assessment that's fair, and also maybe setting up a procedure for the respondent who is has a very low income and low assets to make a showing of that to the hearing judge, so that can be taken into account as well. Because a $5,000 assessment against a wealthy attorney is not the same as a $5,000 assessment against an attorney with a very low income and very few assets. So that's it.
Yeah, thank you, Sean. Jerry.
Just put me in the column with Sean. These seem punitive, out of sync with at least the 16 states that you surveyed. I would be interested also, as if the bar determines to change this, to look at things like, are these dischargeable? In most circuits, they're not. What is the collateral consequence on the lawyer who can't pay them because of resource issues? Does it affect the lawyer's right to resume the practice of law or continue the practice of law? But just generally, to me, they seem punitive, and it's different than what occurs in a civil case or a divorce case where there could be allocation of fees, and mostly sanctioning in trial courts, at least in Illinois, is because of behavior issues. The behavior issue here is what is the basis for the discipline. It's not necessarily the conduct of the trial or the review. So I just think that way too high is my view.
Okay, thank you. Sarah.
I was going to say, I recalled that we discussed this previously, and I thought that, and correct me if I'm wrong, folks, and I'm sure you will, that OCTC, as well as the state bar judges, at least in that discussion, supported getting rid of these costs for precisely the reasons that Mr. Seleg articulated so very well. So if I'm wrong, somebody can please correct me, but I think simply giving discretion to the state bar court doesn't get rid of the sort of interim effect of the potential of having a very large bill at the end of the process for kind of exercising your rights. And if you think about, folks in government practice, public interest practice, who, are not making vast sums of money, they really could be making decisions based upon these costs, which I don't think is something that is fair or that we would want to support. So I kind of support just getting rid of them as opposed to giving the state bar judges more discretion as to whether or not to levy these costs on individuals. Thanks.
Thank you, Sarah. My recollection is more about the sanctions. There was more support for getting rid of the sanctions than there was for the costs themselves. I think the costs were maybe adjusting the costs, but the sanctions was where there was support for elimination. Judge Wang.
Thank you, Justin. I think following up on Sarah's point and your point, that is at least my position in terms of sanctions. I think especially where you have outstanding restitution, I think what money that respondent does have should be going towards making the victim whole. So I feel a little differently about sanctions. With regards to disciplinary costs, I'm just giving the pragmatics. There is a body of law out there, and as Sean talked about, it is in the statute, it's in our rules, the enabling rules. So just to let you folks know how it works is the judges don't set the disciplinary costs. It's that chart that Justin had shown. And when a respondent files a motion for relief of costs, oftentimes OCTC will not oppose an extension of time. So I can break it out to 3 years or 5 years or whatnot, but they do often oppose a relief from costs altogether. And part of it is the body of law, where the legislature has said this serves a rehabilitative function, and that's why those costs do exist. It is up to the legislature or the board to set what is reasonable. So under the rules and the statute, I cannot, as the hearing judge, decide this assessment is unreasonable. All I can do is take a look at the financial declaration, see whether or not there's good cause or special circumstances to deviate, and echoing some of the concerns of Ms. Pansky and Mr. Lear is, you know, this is only anecdotal because this was my case that I got back as a motion for relief. I was not the hearing judge where moral turpitude was found. It was taken up to review, as Judge McGill and some other folks have explained. You're stuck with the costs on review, even if you're not necessarily the. So if OCTC takes the review and, oh, well, if they're gonna appeal the review, I might as well look at this one issue. And if you join the review, then, you know, your costs go up. And then even if you're defending the review and not re-raising different issues, challenging the hearing judge, you still have attorney costs, time, and all these things. So I do think there is this fairness issue we need to address in terms of who's taking the appeal. This one matter that I had, actually, the hearing judge found moral turpitude. The review department exonerated her on all but one ticky-tacky count, similar to Sean's matter. And this was the frustrating thing, Mr. Judge McGill. The authoring judge dropped a footnote and said, hint, hint, go back to hearing and ask for relief from costs, given, you know, the significant reduction in the matter. And it came back to me, and I'm looking at the rules and what my discretion is. And I was frustrated because I did not feel that the rules allowed me to make a determination to reduce what is reasonable costs. So it's a public order, so I can talk about this. I gave the person an extension of time, but I could not find the authority to reduce it under these circumstances. So I'm just giving you folks some background on that as we kind of decide on pragmatically how to deal with this.
Thank you. Alexia.
Yeah, thank you, Judge Wang. You answered a lot of my questions that I was going to ask, if there was some way for there to be an ability to pay hearing. And I'm coming from a criminal background, so the law for us has changed probably in the past couple of years, that we now have ability to pay hearings where judges make the determination, very similar to what you see in family court, that they have the financial assessment forms. But it sounds like that's still, it sounds like we're able to do that here, or the judges can do that. But from what I'm getting from Judge Wang is they can't find that they can take away all of the cost. Is that, am I getting that correct?
If I could jump in, it's special circumstances. So for example, there was one public order where I did reduce it by a third. I can talk about this again because this is a public matter that I issued an order, but the person brought really good cause in terms of making these efforts for 10 years. And he was on disability, and he made there was above and beyond financial difficulties. So when you file the form under 5.130, there's a financial declaration. It does get filed, and the court can take a look at that. But again, you know, when you're looking at the language of the rule, the statute, and the case law, you know, I can't make it up. Okay, you know, you're on disability, so I'm going to strike all the costs. That's, you know, that to me is not enough of a showing given the limitations of the language of the law and the case law. There's basically one case that dealt with striking certain costs when you're looking at that chart. It was respondent J, but that was a really unusual situation decided. I don't even know what year, Judge McGill, you might be able to remember that off the top of your head. But that case, you know, you had the attorney walking OCTC through the allegations, being super cooperative, and basically proved the case for the state bar. And his argument was, we didn't have to go to trial. I told you what I was culpable of. I showed you on my trust account. I walked you through your case. Again, that was such an unusual case. And so the review department said, yeah, we should strike all these leveled costs, and you should be given the cost at the early neutral evaluation. As far as I know, that is basically the only case law out there. So when I'm balancing, you know, the financial ability to pay against what I have, I have good cost to, you know, extend time. And the one that I was talking about, the one where I did end up cutting it by a third, again, he, you know, it was like over 10 years, and he filed 3 or 4 motions for relief costs and demonstrated this good faith effort to pay it. So at that point, it's like, you know, you can't return until you're in good standing and all those things. And I just thought it was fair at that point to go ahead and give him a chance to find an avenue to come back.
Thank you. That was just super helpful, and I think really great background. So yeah, I think it seems like even if we gave the judges more discretion, they can't really do much. So looks like a change or a addition of a sector to assess that ability to pay may be what needs to be done. But yeah, those are just my thoughts.
Thank you. Linda.
Thank you, Justin. I wanted to just offer a little bit more of a different perspective on costs from other licensing agencies. In the Department of Consumer Affairs, there are several statutes that deal with costs depending upon which of the licensing agencies within the department we're talking about. But the main one is 125.3. And in that statute, it delineates, you know, the circumstances under which costs can be collected, and reasonable costs are associated with accusation cases, which are formal discipline cases. And those costs have to be outlined in particular by the agencies with respect to how much time has been put into the case and investigation and up to hearing. Hearing is not included, nor any post-hearing kinds of matters. And there's also case law, a case called Zuckerman, that has followed up on some of these statutes. And the courts have found that various factors have to be followed in considering costs, which include if charges are not all proven at hearing, then the cost should be reduced accordingly by the charges that were proven. And also the ability of the responding party to pay the cost is a factor. The respondent has the duty to raise the Zuckerman factors issues in hearing and have them addressed by the administrative law judge. But even if the respondent doesn't raise the issue, just about any ALJ will raise it on their behalf, just so to consider fairness. And then, as Justin mentioned in his presentation, when the proposed decision goes to the board that will ultimately be deciding the case, the board can reduce or eliminate costs, but cannot increase costs. So I just wanted to give you a little bit more information from another perspective on costs. Also, one last thing, Most of the agencies have cost recovery statutes, and the agencies very much appreciate having the ability to collect costs, both to help them offset their the cost of their disciplinary programs, but it's also a very good incentive for respondents to settle early. So some agencies don't have costs, primarily the medical board does not. And it makes it harder to settle cases from a prosecutor's point of view. So I know you don't like to hear that, but it's true. Okay.
And Linda, I talked with Jenna Jones, who's actually on this commission the other day. The medical board just recently this year was allowed to collect costs again. They had it taken away for a while. They are allowed to collect costs, as you said, up to hearing. So basically the investigation or the little pre-filing, but up to hearing. They don't have any good statistics on it yet because it was only recently implemented, because I was trying to look for similar agencies. When I did peruse other Department of Consumer Affairs agencies and read lots of different orders, the costs were similar to what you would get with the state bar. They were a little more or a little less expensive than what you would get before you hit trial. So in the $6,000 range, those were, a lot of the orders had between $5 and $7 is what I found. A lot of the orders find the costs. It wasn't a comprehensive research project, but I did read a lot of orders to try and get an idea on what other Department of Consumer Affairs agencies did do. So I just wanted to point that out. And thank you, Linda. Judge McGill.
Yeah, thank you, Justin. Actually, that was very good information to learn of your little survey of other boards. But I'd like to make a quick response to Ms. Good and Ms. Mayorga. Yeah, I think we have to have some level of cost collections, because otherwise we would be probably in dereliction of the statute from the legislature. But and regarding with Ms. Mayorga, I think if we did have discretion, we had an actual rule from the board establishing that, I think we would be able to establish a body of law fairly quickly and delineating the parameters. So I don't see that as a problem if the board were able to give us that discretion by rule.
And this is where we are balancing. We're trying to present the commission with all the issues that would need to be addressed, but not get into the details of how we're going to implement this. And so if the commission feels that, granting the judges greater discretion, that can be our recommendation. And then the Board of Trustees gets to decide, and we'll do more analysis on what it would actually take to implement something like that in a practical sense. But this commission, we don't necessarily have the time to get into all the details and the numerous meetings it would get to iron out all of those things. But we are really trying to get on the policy, whether or not we think this is a good policy, and a recommendation that we would like to make to the Board of Trustees.
So I think, Sean.
Yeah, so Justin, I think we can't get into drafting a rule here. I think that makes sense. But I think we need to put a little meat on the bones in the sense of what is our recommendation to the board. And I think, in thinking this through, the statute requires imposition of reasonable costs. So if this is the sense of the commission, my view is that we should recommend that that the board adopt a new rule about the imposition of costs, which lists various factors for the judge to consider, including, for example, the reasonableness of the respondent's decision to go to trial, which is easily assessed. If the respondent makes a record of, this is what, before trial, this is what I offered to stipulate to, and then look at the result after trial. It's either, it's much better for me, and so I was justified in going to trial, because, there is a policy, as someone else mentioned, there is a policy reason to collect these costs from respondents who just fight when they don't have a good defense. And so we want some incentivizing there. The incentives that we have now are perverse in some cases because they're so mechanical. but I think that would be the nature of a recommendation we ought to be moving toward.
So Justin, I know that today's scope is going to be a straw poll. Do we need to bake in any language that's consistent with Sean's recommendations and other recommendations of this commission, or should we just do the straw poll just to gauge members' willingness on whether that first issue of the methodology and approach be changed? Do we need any further direction at this point?
Well, I would like to see what the commission thinks about Sean's proposal, that a new rule on the imposition of costs, because that is, I think that that takes into account what the working group was talking about and granting that. I don't know if there's other people on the commission that would like them to just reassess what reasonable is on the cost themselves, or if imposition of a new rule on cost is sufficient because it would be a change. So that's kind of where I would ask the question to the commission.
All right, so are there any comments as to that issue? Any pushback to Sean's suggestion? Ms. Good.
Yeah, I mean, if we're stuck with the statute, which I don't think creates a great rule here, frankly, because it favors wealthy people over, less people who are impecunious in ways that I think isn't fair. But if we're stuck with it, I could see having a rule that would deter frivolous defenses. But I think it would need to be pretty extreme in one way. Something like filing a frivolous case, could trigger the imposition of costs, not just, what could be reasonably assessed. And I recognize the statute has the language reasonable. But I think otherwise, right, even for, relatively impecunious attorney, with the possibility of having a cost assess in the neighborhood of $20,000 or $30,000 at the end of it, and not knowing how the court is going to exercise discretion is going to have a deleterious effect on their decision to move forward or not. That's separate and apart from kind of the merits of their position. And I do understand not wanting to have, idiotic defenses put on that waste the state bar's resources, but I'm just struggling with how to kind of balance that right now. Maybe somebody else can pick that up.
Well, I was just going to say that the commission could recommend a statutory change. That's number one. And number two, I do think that the kind of consideration you're talking about could be taken into account in the rule that Sean is proposing. But to Justin's point, I also just wonder if that does if it's a sufficiently broad approach to deal with the amount of the cost themselves, not just whether or not they should be assessed in certain situations, but the amount that we're actually assessing. That I wonder if Sean's approach allows us to do both.
I think I'm going to let Sean respond to that, and then I'll go to you, Eloise.
Yeah, I'll just respond to that, Leah. Yes, that would be my vision of this, is that the judge could, in assessing reasonableness, the judge can take into account, the ultimate outcome of the proceeding and adjust the amount. I mean, that would be helpful. Now, I think what we need to struggle with, or maybe this would be a group that the board appoints, is how to set the amount in the first place, because I think I'm hearing a consensus that these amounts just seem too high from an absolute standpoint. But on the other hand, it's not unreasonable to say, a respondent who, without reasonable justification drags the process all the way out to the review department, should pay more than someone who settles earlier. I mean, I just don't know how we can come up with these amounts. That's the challenge. If we want to replace this current schedule, that's a mystery to me right now.
Okay. Eloise.
I just wanted to affirm that Sean's clarification or spelling out of putting some meat on the bones. I want to go back to also to Judge Wang's, I think, pretty clear statement of the need that when she looks for a statute or for a provision to exercise discretion in assignment of costs or adjusting, whatever is the cost, she doesn't find that available to her in the same way that Superior Court judges have in state court. Did I hear you correctly, Judge Wang? Okay, that would be my comment.
Okay, thank you. Shanae.
Thank you, Justin. I know in Cable's discussion with Leah, and I don't know if this is appropriate now to bring this up, Cable was of the view that, maybe the state bar should do something to help relieve some of these costs for respondents going through the discipline process on the front end, like a right to representation for respondents that are within a certain income bracket, something akin to like the public defender's office. So I don't know if that's appropriate to discuss right now. And then also, I agree with Sean that we're kind of having this discussion with, and I agree that costs should be reduced, but reduced to what? So I would like to get hear some more discussion on, how will we propose to reduce costs?
We have to look at the underlying methodology. I don't know right now, for example, I'm assuming we're using the fully burdened cost, like with all of our direct overhead time. I mean, indirect overhead applied to the OCTC staff time. There's ways to adjust that. We just have to look at the underlying methodology.
I'm not sure that it's typical in other jurisdictions to build in a component to costs that reflects staff time. I know there's like Wisconsin does that, but I had not had the sense that that was part of the equation in most states. Doesn't mean California shouldn't have that, but if you're looking to reduce the costs, one principled way to say is we don't think we should be capturing the staff cost side. It's more out-of-pocket costs, but I'm just trying to come up with a construct that doesn't make this just a dartboard.
That would be really different. That would significantly reduce costs, for sure.
Yeah, and that would definitely need a statute change because it's the cost of investigation, hearing, and review in the statute. Sean.
Sorry, that's stale.
Oh, okay, sorry. Judge McGill.
Yeah, so when this issue was first getting started, when we were starting the ad hoc commission, I did reach out to other adjudicatory agencies, to the National Conference of Lawyer Disciplinary Boards. And I think Jerry's point is right. Most states really look at, because most of them have volunteer referees, masters that travel around their state and do that. And I think most of those costs in those other states are attributable, or they try to recoup those costs of the hearing people out doing their traveling and the cost of that, not really their administrative costs. But again, I'd like the idea that Justin had come up with, and it did some preliminary research of looking at what other boards are doing and looking at costs. So that $5,000 to $7,000, if that's investigative costs, I think that could serve as a good baseline for an assessment of cost, and then leave it again up to the particular judge that's assigned the case to decide based on the information that the respondent would provide as to what then is, really the reasonable cost based on that particular scenario. So I think that's both reducing overall the size of it, and then also allowing some discretion to judges to figure out in the hearing department what is the appropriate level of discretion by setting this within the board rule.
Okay, thank you, Judge McGill. Judge Wang.
I think one easy option, well, not one easy, one low hanging fruit, in my opinion, is the multi-day versus the single day. And Ms. Pansky jumped in, so I'm sure she'll add to this point. At initial status conferences, I always say, how many days does OCTC think they'll need? And respondent, are you going to be putting on a mitigation phase? And I always feel strange asking at that point, because the reality of what Sean just talked about, not defending the E&E mediator in your case, Sean, but I do warn respondents, multi-day trials, the costs do go up quite significantly, but I'm not suggesting that your defense be silenced. I'm not saying you're not entitled to mitigation, but that is a big jump between the single day and the multi-day. And frankly, not all DTCs are the same. I've had some DTCs who are very efficient. You stipulate to these facts, these exhibits, boom, boom, boom. These are the 10 questions I need from you. Move on, because we have a stipulation. Then there are other DTCs who will stipulate almost everything, and they're still going into the trial as if there's no stipulation at all. And that's very difficult as a neutral, because I'm thinking of the cost and thinking you're entitled to put on your case, you're entitled to put it on, you know your case better than I do, but in the back of my head, if I were the prosecutor, I would be able to put this in 10 questions. And that's what I struggle with, because I'm thinking the costs are ticking and the respondent is going to be, sacked with a multi-day trial. So even if the discretion for the judge to impose, the 1 day versus multi-day, I think we would be making progress.
Okay, thank you, Judge Wang. Linda.
Following up on what Judge Wang just said, I think a very important part of the cost formula has got to be discretion, and that's with the executive director in making settlement decisions, as well as the different layers of as a case progresses with the judge and with the ultimately with the decision maker and with the review process as well. So there's got to be discretion based upon a totality of factors for any particular case. Ability to pay being one, reasonableness of the defense being offered, and at what juncture the case is settled. All those things have to come into play, and every case is different. So it's just discretion has to be a big part of it.
Okay, thank you. Ellen, welcome.
Thank you. I'm sorry, I had to testify in a Superior Court trial today, so sorry I'm so late. Another area that I think bears attention are those cases in which there are dismissed counts. And we can't seem to get a handle on the statistics. The staff has done a yeoman's job of trying to help put together statistics about dismissed counts and moral turpitude charges that end up being dismissed after settlement or trial. And there's something of a disconnect that we're still trying to sort. But there is a fairly high prevalence in my experience and the experience of my colleagues in the defense bar of cases that are taken to trial having one or more, often multiple counts dismissed, either by motion or by the court after trial. And I think it's unfair for the respondent to have to bear higher costs because the multiple counts required a longer trial if those counts are in fact dismissed, either by stipulation or by court order. So I think that's another area that we should look at.
Okay, thank you. Leah.
I'm just wondering what folks think about, I think what we heard is the case on the DCA side, but just not imposing any costs at all once a case gets to hearing. Then you're not dealing with multi-day versus not multi-day, whether counts are sustained or not. You just don't impose costs at that from that point forward.
So I'm just understanding you, Leah. That means that like the DCA, you would just stop assessing cost at the end of the investigation phase.
Yeah. Or maybe, you know, you could only do it if it was, I don't know what the factor would be, but it would be if the choosing to defend your case was an egregious waste of court time, there would be that kind of a finding. Because there is something concerning about disincentivizing people to take advantage of their right to defend themselves, regardless if the defense has merit.
What would that cap the costs at, Justin? I can't remember your chart.
It would cap it at $8,500 for it, basically $8,900 for original proceedings and $8,500 for conviction referrals.
So 3x the typical in your survey cohort.
Yeah.
Justin?
Yes.
Also, I think you should take a look at the second step in the process where matters that settle prior to the filing of notice of disciplinary charges, because I think that's pretty much, I mean, correct me if I'm wrong, Steve or Melanie, you know, that's pretty much when the investigation period ends, is when the NDC ultimately is filed.
I don't know if Steve or Melanie want to comment on
I
that.
think that's probably a fair comment.
Okay. I just wanted to put those back up so everybody had the refresher and the different amounts, and now I will bring them down again because I can't see anybody. And Sean, you have your hand up.
Yeah, so Leah, I thought your thought's a good one, but I think we have a problem with the statute because not everything's in quotation marks in the memo, but this memo says that the statute mandates the state bar to collect the reasonable cost of investigation, hearing, and review. So having an absolute rule that hearing and review costs are off limits, I think, is a problem. As you say, we can certainly propose a legislative change, and we might consider that. But we could perhaps incorporate, Leah, to implement your idea, perhaps we could incorporate the concept of unreasonableness. In other words, costs, you know, to make it clear, the state bar court does not have to impose costs unless the respondent's decision to go to trial / hearing was unreasonable. I don't know, that would track the language of the statute.
Yeah, that's what I was thinking, something like that.
That might work. That might work.
Thank you, Sean. Linda.
Yeah, I was just going to mention that the Zuckerman case is the California Supreme Court case at 29 Cal 4th. I don't have the page number, but that's a case that governed cost recovery for the Department of Consumer Affairs. It came out of a Board of Chiropractic Examiners case, and it evaluated all of these factors that we're talking about here. So I think it would be a good one to take a look at for board staff.
I'm taking notes. Thank you, Linda. Sarah. You're on mute, Sarah.
Sorry, 2 years into the pandemic and I'm still on mute. I was saying, I think where I come out after having listened to this discussion is I don't really see a a compelling reason to keep costs in. So if one of our options is to get rid of the statute entirely and not have any cost shifting, I think we should get rid of it and maybe suggest, to get to the other point of people who are frivolously abusing the process and wasting state bar resources on a frivolous defense, adding something along the lines of, as in civil litigation, some kind of discretion to the state bar court to impose costs or sanctions if they believe that there has been an abusive process or a frivolous piece of litigation. But having the standard be pretty darn high so that it wouldn't come into effect on every case, but would at least give the state bar court the option of using it in hopefully appropriately limited circumstances. I don't have a sense about how common that is. So I think that's where I come out. Maybe I'll be in my own category of one, but that's where I'm at.
Okay. Thank you, Sarah. So I think I want to take these one at a time. Well, the trouble is, I think that I'm getting from the commission that the costs do not seem reasonable in terms of how they are currently constructed. And there is only a certain amount that you can do without a statute change. And we're trying to give a little more direction than we don't think that's reasonable, do different. And I think that the providing what other DCA boards do will help us form the argument for change. And then with Sean's potential new rule about the imposition of costs, I think I want to take a straw poll about that. So Sean basically proposed a new rule that the state bar should investigate or adopt a new rule on the imposition of costs to grant greater discretion because of the things we talked about, because of if you prevail on multiple allegations, but one minor allegation is there, you still impose the full costs, and the review, kind of a penalty for continuing to go for review even if you win. And so a rule crafted to do something like that. I don't have the exact language. That's what we can work on in between meetings. But is there support for the commission for that rule? That's where I'd like to kind of take a poll, if everybody on the commission would raise their hand if they have support for that that rule with the language, the definite language to be filled out. I'm seeing lots of hands. Even those not on screen, I see lots of hands. So it's close to unanimous of the members here.
Justin, I'm just going to suggest maybe a slightly different process for this. I think
Sure.
There's one option which would be advance a recommendation for a statutory change to eliminate all costs. That's one that we could write up for the next meeting. Another is if folks don't agree with that philosophically and or if it's not viable, right? Then there is the Sean's approach, which is revising or drafting a rule to define reasonableness. And that may include, for example, this issue we discussed about, is it reasonable to assess any fees for hearing and review? And when does that, what is needed to justify or to be reasonable in the hearing and review context? So I think we could put forward essentially a couple of different proposals for vote for the next meeting. One, statutory change, no cost. Two, revise create a rule around reasonableness that basically precludes or drastically restricts any cost being assessed for hearing and review. An option that does not. And then we could also put forward a proposal for revisiting the dollar amount of the costs, irrespective of when they're assessed. Maybe we have enough to go on and suggesting without doing a straw poll. But I don't know if others disagree with me. I'm just kind of hearing the two big choices are no costs at all, or if you have costs, developing criteria for when those costs could be imposed and what the amount of the cost will be.
And Leah, if I can add one more option I've heard, which is replacing the current statutory requirement to impose reasonable costs with a sanctions mechanism for respondents who engage in unreasonable litigation.
That's right.
Okay, so I got, I think I have all the potential things to vote on. Is there anything we're missing from anyone on the commission? Did we encompass all the potential changes that should come up for a vote? Or better yet, if we haven't done that, please let me know. I see a couple hands raised. Sharon? Or was that a vote hand?
No, I just wanted to say that, I mean, if we come up with removal of all costs, that will encourage many people to go all the way, even to the appeals. So most probably it's best to come up with a system where we could come up with or define reasonable costs.
Okay. Thank you. Greg.
I'm not expressing any opinion, but turning to the statute, I just want to point out that under subdivision B, there are 3 aspects of the cost that must be imposed either by state bar court in a approval situation or by the Supreme Court, because the Supreme Court is also required to impose these costs. The reasonableness of the cost of investigation, hearing, and review is only one of the 3 costs that must be imposed. The other 2 are the actual expense of the transcript and the time for the reporter. And the second one is the expenses paid by the state bar, which would qualify as taxable costs recoverable in a civil proceeding. So, and those are obviously predefined under the Code of Civil Procedure. So if the recommendation is to suggest that the legislature eliminate the imposition of costs entirely, obviously that would wipe away all 3 of those aspects of costs. But if we only start tinkering with the reasonableness of the costs associated with investigation, hearing, and review, you still have to deal with these other actual costs that must be imposed.
I think that's true. I mean, I know that's true, but from what I've seen, those are really de minimis in compared to what the staff time costs that's the bulk of what we're charging for. And not reporters. We don't have reporters.
The only thing I would add is, again, those transcript costs, again, depending on the length of the hearings, can be fairly de minimis, $500, $600 for one day. A lot of our trials do resolve in one day. Judge Wang can correct me if my historical recollection is wrong, but we do have a number of 2 and 3 day. They're kind of rare once they get to 5+ days. But again, Judge Wang can correct me if I'm wrong about those observations. So, I mean, again, so a multi-day trial, 5, 6, 7 days, it could easily be $3,000, $4,000 is my estimation.
Okay. Ellen.
I agree that usually those costs are de minimis, but I do want to point out that as the rules are currently applied, if the state bar appeals and loses on appeal, the respondent still has to pay to get a certified copy of the transcript. And that's always very difficult to explain to respondents.
Thank you. Jerry.
Justin, it just seems unfair. We're talking about costs that could easily get into the $30,000 and $40,000 range. I would imagine in most cases, a respondent is represented and is paying a lawyer a fee. to do this work, which is not easy work to do. We haven't even gotten to the sanctions yet. If this is rehabilitation or based, what chance does this give a lawyer who is not from a wealthy practice setting to actually become rehabilitated? To me, it just seems beyond reasonable. And I know that's in the statute, and I've heard discussion of that. It just seems, and then I wonder what effect it has on the lawyer's ability to return to practice. I mean, if any of us had to pay 50 grand or 70 grand for all these different bundles, maybe 100 grand, it wouldn't be a big deal. And the big deal is discipline, right? That's still the big deal. We're losing sight of that, I think, to some extent.
Yeah, those are, thank you, Jerry. Those are significant costs. And like Judge Wang has said, they can't grant relief, but Judge Wang has mentioned, and I think Judge McGill has mentioned that whenever they've asked for relief in terms of time, it's almost always granted. So they are granted time, but they're not granted lessening. Okay, I think I have enough to go on the cost piece. And so I'm gonna, hopefully the sanction piece will be much quicker. I will provide a brief overview. We kind of talked a little bit about sanctions. So let me share my screen.
Or Justin, do you want to do a straw poll on who wants to just eliminate costs completely, or do you have a good sense of that already?
Well, I think that the plan, and correct me if I'm wrong, Leah, is to write these up and bring them to the commission at the next meeting for an up or down vote, where it's an actual vote. So let me share. So can you see my screen on sanctions? Okay, a brief overview of sanctions. The sanctions go to the Client Security Fund. They were authorized in statute in 1994 by Business and Professions Code 6086.13. But this was one of the things that during a review, we actually found that we weren't imposing sanctions. So in 2020, the state Supreme Court issued guidelines to implement these sanctions. Cases that involve disbarment, suspension, or resignation with charges pending. So it's limited cases that actually get the sanctions. And the statute calls for $5,000 per violation with a $50,000 cap for the whole order. Now, the state bar adopted a rule 5.137 on the imposition of these sanctions, and it adopted guidelines for these sanctions to be implemented. And so the guidelines, not that they can't deviate from this and still do $5,000 per allegation and $50,000 total if they see fit. The guideline is $5,000 for disbarment, $2,500 for an actual suspension, and up to $1,000 for resignation with charges pending. And so the question for the ad hoc commission is, should these sanctions be eliminated? They have recently been instituted. At the discussions at the meeting were the discipline costs are already high, and this seems to add on to them, to be more punitive on top of what is already high costs. And this is where, Sarah, you had mentioned before, there wasn't a lot of support for these sanctions from any members on the working group. There was no one advocating for them. And so this is where I would like to get the commission. I don't know if I missed anything, if anybody from the working group wants to talk about the sanctions, or if any commission member wants to talk about the sanction, but there was kind of a theme of that the sanctions weren't necessary in light of all the discipline costs. So I kind of open it up. Judge McGill, you were on the working group.
Yeah, and we're dealing with this. So just again, to kind of give everybody historical perspective, because the rule is focused more on the ultimate discipline that's being recommended. For example, for summary disbarments, usually OCTC has been requesting $5,000, and we've usually been approving those. Also for disbarments, I think it's usually a request for $5,000. If there are actual suspensions, the request I've seen usually is the $2,500 maximum. The only time I've seen where real waivers, where OCTC has not been recommending an amount is where resignations with charges pending. And it's usually because the respondents are elderly or on some sort of governmental benefit. And it seems apparently pretty clear that, collecting a sanction with the resignation just isn't in the best interest of anybody. And again, I invite anybody else from OCTC or from Judge Wang if I've not summarizing sort of our approach. So just so you understand what we're trying to do in this very new environment, because we've only been doing this for really about a year, maybe a year and a half. I can't quite remember when we started actually doing this.
Thank you, Judge McGill. Does anybody else have any comments on sanctions? And Ellen?
Yes, there's a great universal objection to sanctions on the part of the respondents bar. The view is that it's already extremely difficult for respondents to pay, if you go to trial, $9,000 and up, and you're being sanctioned already by the imposition of discipline. So what is the purpose of monetary sanctions other than punishment?
Sean?
Yeah, I mean, I agree with Ellen. The sanction statute is kind of an anomaly, and it's inconsistent with all of the case law about discipline that says it's not supposed to be punitive. So I do think we should recommend that the statute be repealed.
Thank you, Sean. So does anybody have an alternative? Oh, Shanae.
I'm sorry, I have a quick question. I thought the sanctions go to fund the client security fund.
They do.
So if we get rid of sanctions, and how will the victims be compensated? They're wronged by an attorney.
Yeah, it's a very, because it was only recently implemented and it's a very, very small percentage. I think we collect, now granted, because it's only recently implemented, you have to take these with a grain of salt, but I think we collected $17,000 in sanctions last year. Now that has increased this year. I think we're at a little over $20,000 in the first quarter of this year, but it was only recently implemented. And the total amount that the client security fund reimburses is in the I think it's 6 point something million every year that we reimburse to people. So this isn't a primary source. It's not even a secondary, third source for the client security fund.
The primary source, Shanae, is the $40 per attorney. That's added onto your licensing fee.
Thank you. And I used to chair the Client Security Fund Commission, and I thought, we had discussion over the years to, for the state bar to kind of ramp up its efforts collection efforts to go after these attorneys. But I don't know where we are with that.
That's different from the sanctions.
Okay.
That's the actual collections when we've paid out on the fund. And so then we go after you to reimburse the fund for that payment. So if we paid out on your behalf $50,000, we go after you for $50,000. That would be, the sanctions would be on top of that.
Thank you, Leah.
Thank you, Shanae. So I think I have direction, unless anybody has an objection. The recommendation here would be to eliminate sanctions, to bring that back for a vote, unless I see anybody object to that, we can move on to the next topic. And I don't see any objections. And I can move on. Brandon, I don't mean to take over the chairship. So
no, I'm more than happy to cede the chairship to you. So appreciate your leadership in this.
Thank you, Brendan. So the next topic that I would like to discuss is the Early Neutral Evaluation Conference. We met several times with the ENEC conference, and the recommendations from that working group were split. And so some of the working group members are here today. Ed, unfortunately, isn't here today, but we can present his point of view. I have a short PowerPoint that I will provide to give a brief overview of the Early Neutral Evaluation Conference. Hopefully people can see my screen. Nodding yes, somebody, okay. So the two goals are determine if the commission supports early neutral evaluation conference in criminal conviction matters, and determine if the commission supports developing time limits between the first and subsequent ENECs. The purpose of an ENEC, a brief refresher, is to obtain a judicial evaluation of OCTC's case. So the judge gives the parties an evaluation of the facts and charges. If the parties resolve the matter, this is where settlement can occur early on in the case. This is a brief settlement process, so you can see the ENEC here. If the case settles, great. If not, the charges are filed in state bar court. If they waive their ENEC, the charges are filed in state bar court, and that's in red because that is what makes the case public. And so some of the concern was about not allowing in criminal conviction cases settlement where the case does not become public. Currently, where the holdup is, Business and Professions Code 6101C says within 30 days of receipt, the Office of Chief Trial Counsel shall transmit the record of any conviction which involves or may involve moral turpitude to the Supreme Court. And I won't read the whole thing. The Supreme Court is actually state bar court. They have delegated that authority. So OCTC gets these convictions and then only has 30 days to review and determine whether or not it's moral turpitude and send it on over to state bar court. This was recently extended. They used to only have 5 days. It was extended to 30 days. I think we requested longer than that, but that's what we were given. And that timeline, that constraint, is the reason why ENECs do not happen in criminal conviction matters. This just says that the state bar court, so that filing with state bar court, once it's transmitted to state bar court, it becomes public. And then from there, here we go. Does the ad hoc commission on the discipline system recommend the deadline for transmission for criminal conviction matters be extended to 60 days to allow for an ENEC? And then does the ad hoc commission on the discipline system recommend that timelines for additional ENECs be developed? The second part of there, and I'll just take it down. The respondent has 10 days to request an ENEC, and then the ENEC is held within 15 days of that request, or is supposed to be held within 15 days of that request. There is nothing that prevents multiple ENECs from happening. And oftentimes they do happen where they think that settlement is possible. And so there can be 1, 2, 3, multiple ENECs. There are no more time constraints for those multiple ENECs. And so the concern was raised by some of the members of the working group that that delays the notification to the public. So if there's 40 days between the first and second ENEC, and then an additional 20 days between the second and third, there are no time constraints for that. And so that is an area where the working group was split. There weren't firm recommendations. It was a 4-person working group. And in terms of extending from 30 days, which would require a statute change, to 60 days to allow for an ENEC in criminal conviction cases, the members were split. some thinking that it was very important. ENECs, ADDC was of the opinion that ENECs are always valuable to have for respondents because they give a judicial evaluation of the case. And so it's always used for respondents. And then there are certain cases, although I think with our findings, we found that it was actually 3 cases could have potentially settled without going public. So it wasn't a large majority of cases, but there were a couple cases that if you would have had the ENEC, it likely would have been able to settle without the charges going to state bar court, and therefore that it was a private reproval and it would have remained private. Whether or not this was worthy of a statute change was kind of the concern. And there was also a concern on resources because ENECs take resources from, just getting on the judge's calendar, and also OCTC, they require resources. And so whether or not for the minimally amount of people impacted by it, was it a judicious use of resources, was kind of the counter argument. And so with those 2 arguments being made, we kind of had a split vote. So I don't know if anybody from the working group would like, Ellen has raised her hand. I think she will represent Ed, and then Melanie, thank you for raising your hand to represent the other side. So Ellen, if you'd like to comment. And you're on mute. Ellen, you're on mute.
Thank you. Thank you. So Ed's not here. He's in mediation all day today, I understand. And we have talked about this before, but I would like to go back a couple of steps because there's some information that has to be considered. While the statute does talk about transmitting the record to the review department within 30 days, the statute also explicitly says that the record has to be transmitted if it appears that the crime involves moral turpitude or other misconduct warranting discipline. And as has been confirmed on numerous occasions, OCTC now and always looks at the convictions to determine whether or not it's a crime that appears to involve moral turpitude or other misconduct warranting discipline. And there are cases that are not referred because OCTC has discretion to make that determination. The disconnect is that the respondent is excluded at that phase. There is no involvement by the respondent, and the respondent has zero opportunity to try to demonstrate that the conduct underlying, it's always going to be a misdemeanor, by the way, the conduct underlying the misdemeanor did not involve either moral turpitude or other misconduct warranting discipline. And that's the missing piece. Once the record gets transmitted, the proceeding becomes public. And practically speaking, the respondent loses the opportunity to obtain a confidential disposition. I don't know where the statistic comes from that there were only 3 cases that could have been resolved in a confidential way, because I can tell you that a major issue came about after everybody got re-fingerprinted and new DOJ records went to OCTC, and OCTC is in the process of determining whether misdemeanor convictions, overwhelmingly DUI convictions, are to be filed, are to be transmitted, and then they end up, as a matter of course, being filed and being public. And I can tell you anecdotally that my office has had many of these referrals in DUI cases where the DUI is 5, 10, in one case, 17 years old. There is no opportunity for the respondent to even be heard before this gets transmitted. It is extremely unfair. And I don't believe that the way the statute is written necessarily requires modification, because we already have a system where OCTC has the ability and does in fact exercise discretion in determining whether it looks like a conviction is appropriate for transmission. I also think that the defense bar is going to vigorously refute the idea that having an E&EC adds any appreciable delay to a case. It's just not the case. The fact of the matter is, the Office of the Chief Trial Counsel has a backlog. It is itself cannot accommodate scheduling an E&EC within 2 weeks, even in non-conviction related matters. I mean, let's be real. It's not possible to hold the E&EC within 2 weeks of having a determination that there's probable cause to file disciplinary charges. And many cases settle at the E&EC level, saving judicial resources. I don't know how long ago it was, but I recall Judge Wang speaking to the benefit to the court of allowing multiple sessions of an E&EC. And at that presentation, I can't remember if it was the working group or to the whole commission, but I pointed out that in my experience, if there is a second session, it's held within weeks. We're not talking about a lengthy delay. And if you can take a couple of weeks, present more mitigation, present a fuller picture of what actually happened. And as I said before, a lot of times respondents don't have any clue what's happening. They may have responded to an investigator some months ago, and then they get a letter saying, we've decided to move forward and you've got to come in within 2 weeks. They are not aware of the impact of developing, for example, character reference materials, and you need a great volume of them. The State Bar won't consider 4 or 5, you need many, and that takes time. And for the respondents to go to the E&EC and really only become aware or realize at that time that there's much more they can do to get to an acceptable degree of discipline and stipulate, it's imperative to have a second session. And that this is a way to avoid pretrial work, pretrial conference and trial, a VSC that may prove to be unnecessary. I really think it's imperative that we address and significantly modify the E&EC system. It will make a much more effective use of State Bar resources. Thank you.
Thank you, Ellen. Melanie.
Hi, thanks. So a couple of things. One is that I want to go back to what Justin talked about originally, and that was the purpose of the E&EC, and that is to evaluate OCTC's case. That's what the purpose is. And so a byproduct of that could be a settlement, and that's a good thing. But the reality is that when we're spending more time in E&ECs and going to multiple E&ECs on cases that are going to end up in public discipline, it has become more than just evaluating OCTC's case. So if we want to revamp E&ECs, then maybe the discussion should be, what is the purpose of an E&EC, and expanding it, because for what our purposes are today, it's simply an evaluation of OCTC's case. When it comes to criminal conviction matters, I just want to highlight that these are public matters. Criminal convictions are public matters. And the benefit of an E&EC is to keep matters confidential and not public. So it doesn't really make sense in a criminal conviction matter that's already public to afford the respondent an opportunity to go to an E&EC in any event. Also, the reality is, and the working group saw in a number of our discussions that, of those cases that are transmitted, the criminal conviction matters that are transmitted, a very few of them actually result in some kind of non-public disciplinary outcome, such that expending sort of our time and resources on revamping the statute or recommending that it be changed really perhaps doesn't make much sense. Some other things, and Ellen touched on this, is it is a significant amount of resources that we're talking about if we're going to start building in E&ECs to criminal conviction matters. And it's not just the time, it's just the staff resources. And the fact is that we already are strapped for resources with the cases that we have. So we would not be in favor of building in ENECs to criminal conviction matters. I would also say that, and I think Justin highlighted this, it's been very recently that the statute was changed to 30 days. Before it was 5 days, and that was virtually impossible given the volume that we deal with. We asked for more. I don't recall the number that we asked for, but what we got from the legislature was 30 days. And so I think that's realistically what we can expect. When it comes to this idea of timelines around ENECs, and this is sort of separate and apart from the criminal conviction matters, again, the ENEC process has become more than just an evaluation of OCTC's case. And we are of the belief that when a case is likely to result in public discipline, that we should not continue multiple ENECs over a period of time, even if that were to mean that there's a resolution for settlement, which of course is a good thing. It overall does preserve court resources. But again, if it's public discipline, you're losing the value of the ENEC to begin with, which is really an opportunity at a private resolution. Thanks.
Thank you, Melanie. Judge Wang.
Okay, there's so much to unpack. I think Justin, you and Melanie and Ed, we probably met the most out of all the working groups, and we've hashed out so many of these ideas. So bear with me as I try to unpack some of those things. What Ellen and Melanie both touched on is basically the idea of resources and who's carrying the burdens. So I've repeated the court's view. I'm putting in the same amount of work, whether or not you call it an E&E or a VSC. So I don't really have a dog in the fight in terms of judicial resources. So whether it's an E&E or a VSC, I'm going to make the same efforts in terms of settling it. What Ellen was touching on in terms of judicial resources from what I've raised in the past is what I've been calling a bottleneck. If these matters can resolve at an E&E stage, they're not fighting for my calendar for that 125th date in which I'm supposed to set my trial. So every case that's filed that hits my calendar, the last day is 125 days from that date. So if it's a Girardi case, or if it's a second time DUI, it still has the same last day. So for me, if I can get rid of these cases before that time starts ticking, it's more efficient for me. I don't have to fight and continue these other cases that are competing. So that's where, where Ellen and Melanie are talking about resources. But in terms of the work itself, it's the same, whether or not you call it an E&E or a VSC. We're just talking about the time pressures being different from OCTC's perspective and the court's perspective. So I just want to put that out there. In terms of the private approvals, Ellen, I was surprised by the numbers too, and that's why I asked Araya to pull out the dismissals as well, because to me, I think the dismissals as well as the privates, those matters, had they been in the E&E phase, they would not have been made public. We wouldn't have it on the State Bar Court website under JARA. So I do think that that needs to be considered as well. In our working group, aside from the 30 or 60 day or whatever fix that was proposed, I was still wondering if we could explore, we can keep the same referral date. It's just when OCTC transmits it to review, there's no notice of hearing yet. So when you're looking at original discipline matters, it is on the notice to show cause. That's when something becomes public. I don't see why the fix can't be, you still get the same amount of time, send it to review, review refers it to hearing for an E&E. And only if a notice of hearing is then sent out, then does that make it public? To me, that makes sense. I don't know if that is more palatable for OCTC or for the other folks on the other end of this, but to me, it seems fair to allow an E&E process for criminal conviction matters. I do disagree a little bit with Melanie and what Steve had brought up about it already being public from a conviction point of view. So police reports are not part of the public record in criminal cases. So even I brought up the expungements, and Steve said, well, under JARA, the court record's still there on an expungement in a criminal conviction matter. Just to catch everyone up, I'm sorry, getting ahead of myself. So in criminal cases that are expunged, you can still come to the state bar court. You can still be found subject to professional discipline on a case that's been expunged. Expunged records in criminal courts are still out there, and that's what Steve and Melanie's point was, that this is public anyway. So what's kind of in terms of what's so significant about any, but criminal convictions, the police reports are not part of it. And so when you have the transmittal here, you're going to get the docket. Sometimes you get a statement of probable cause, sometimes the police report. So there's a far more information that becomes part of the transmittal and becomes part of our court record that you can pull up on the state bar court website that you cannot pull up in a criminal court. Expunged or not, you go to the criminal court, it's very limited. You have the charging document, you have the minutes, you have the resolution. You don't have the detail that you get from here. So those are a little bit of the nuances I wanted to cover in terms of those points. And I've repeated this in earlier conversations. I think OCTC recognizes the limit in terms of their inability to investigate criminal conviction matters. So they do transmit before they've had a chance to investigate, before they've had a chance to get the police report. But once it's transmitted, it becomes public. And I think George will appreciate this. They worked hard to get a fix to the rules so that they can do a deposition of the criminal for conviction referral matters. To me, that is it should be somewhat of an acknowledgement that their hands are tied in terms of getting what they need in a timely fashion. And so if you have that reality, I don't understand why the corresponding reality is not that the respondents should have the opportunity to present their case to show that this shouldn't be transmitted or made public, because this is 20 years ago. I have these records. I had a conviction referral matter. They went to the mat about it. And at the end of the day, there wasn't really that much proof they could get off the dismissed counts. So basically OCTC was saying, this is what the original charges were. He pled down to this. We think we can show that, right? And we can show moral turpitude. And they end up not being able to produce that evidence. But the respondent said, this is 20 years ago. I could have shown not only that your case wasn't proven by clear and convincing evidence, but I would be able to show that I would have been exonerated of those charges. But I don't have those records anymore. So I out of fairness, and it does cut both ways, I think an E&E is appropriate for these matters.
Thank you, Judge Wang. That was a very succinct recap of all of our meetings. And
I tried. We've discussed so much over the course of several months.
We did. I want to think some clarifying things that I want to add on to what Judge Wang has said, and then Ellen, I'll get to you and Sean. And Ellen, we have a moral turpitude working group, and I was going to give a brief update on that later, but I think it fits right now because I think we are looking at some of the things that you're talking about, Ellen, because the moral turpitude working group was going to look at whether or not moral turpitude was being overcharged or charged more. And the initial research looked into that and was only looking at like original matters, original cases, and found that it wasn't statistically dismissed any more than any other charge. Now, when Ellen brought some cases up to our attention and for our review, a lot of the cases, almost all of the cases were criminal conviction matters. And our original analysis hadn't taken that into account. And so what we've done, the moral turpitude working group still has work to do. We've turned to look at that analysis now and include those C cases. So when Ellen's talking about that these cases were transmitted and then ultimately dismissed, well, now we're going to try and get the actual statistical evidence on that and to see where those come out. And that issue itself is going to be talked about in the moral turpitude working group. I know they overlap with the NEC, but I wanted to make it clear that another working group is looking at that area and is kind of doing research on it to bring back to that working group to see whether or not that is the case. Now I will turn it back over to Ellen.
Thank you very much, Justin. So I'd like to go back to what Melanie started with and talk for a minute about the purpose of the ENEC. Strictly speaking, Melanie is correct. You know, the definition of an ENEC is for the parties to get the judge's neutral evaluation of the case. But in practice, from the very beginning, and I know because I was on the commission where Justice Elwood Louis is the person who said, well, in federal practice, we have this ENEC process, why not import it? And it was imported, and it's decades ago now. The truth is, from the very beginning, the ENEC was treated as an early settlement conference. It always has been. And I've said this before, you know, I can't speak to unrepresented respondents, but I can tell you, for those lawyers who are respondents counsel, if we go to an ENEC and the ENEC judge says, this is the way I see this case, this is the way I see the violations and the disposition, then as response counsel, I'm going to take that very seriously. And I'm going to talk to my client about the fact that, you know, we have to take into consideration the judge's evaluation of this case. And I think both sides have to do that. And depending on, you know, the deputy trial counsel, some take it seriously and some reject it out of hand. But if in fact OCTC's policy is to go into the ENEC and treat the judge's evaluation as take it or leave it, then that's where the problem lies. That's where we have to go back and fix the proper emphasis to be placed on this level of the proceeding. Because the whole point is not that we're going to all waste our time. We write these elaborate briefs, we do the legal research, we include case authorities, we include, as I say, large numbers of character reference evidence and other mitigating factors, oftentimes, you know, psychological reports or other medical reports. A lot of effort goes in to putting a complete presentation before the ENEC judge, and it should be given the credit that it deserves. And I would like to see a more robust ENEC process. It should be treated by both sides as the last best time to resolve a case before it gets filed. And then the only other point has already been made by Judge Wang. Not every conviction referral is public. There has to be an initial transmission to the review department before it becomes public. And I would endorse Judge Wang's recommendation that you build in a confidential transmittal of the record to the review department and the ability of the trial judge to refer the case for an ENEC before it becomes public. And I can just tell you, if we're going to look for a moment more at the conviction situation, the review department has since 1993 been issuing decisions on DUI convictions regarding the lack of moral turpitude and also the appropriate degree of discipline being either an admonition or a confidential private reproval if you've got a non-aggravated, highly mitigated set of circumstances. And it's just not fair to say to a respondent, well, you would have gotten a private disposition had we not transmitted it, but since we did, now that's lost to you. And that's why we have so many stipulations to a public approval, because at that point, it doesn't pay for the respondent to spend thousands of dollars in attorney's fees and thousands more in costs to get a approval, which is going to be public anyway, simply because the proceeding has been filed. It's fundamentally unfair. Thanks.
Thank you, Ellen. And that reminded me, one, I will get right to you, Sean, but In the discussions, we talked about that there was a re-fingerprinting issue with the state bar, and that caused, we were not getting subsequent notifications from the DOJ. And so it was, we learned this, and several years ago, we re-fingerprinted all the attorneys in the state of California, which caused convictions from many years ago to show up. And so that's what they're talking about. Judge Wang and Ellen was talking about, that 20-year-old DUIs came up in this re-fingerprinting process. We are almost through all of that. So we are now set up to get those subsequent notifications. So in a couple of years, we should not have that problem where 20-year-old DUI convictions come up. And I just wanted to point that out because that was discussed at the meeting, to give context to everybody. Now, Sean.
Thanks, Justin. So I just want to be clear. So we have two very different issues on our agenda. One is criminal conviction matters. The other is, in general, whether there should be some guidelines about second and subsequent ENEC. So are we trying to focus now on the criminal conviction issue, Justin?
I think so, yes. I mean,
I think we should.
On both, but I think that's what we're focusing on.
I think we really should, because they're just such different issues. And so, my view on the criminal conviction issue is, I think I understand Ellen's point now, but the problem is it requires a statutory change. This is clearly not something we can do on our own, because someone, I don't know if it was you, Justin, or I can't remember who to give credit to, but the statute says that OCTC shall transmit the record of any conviction which involves or may involve moral turpitude, blah, blah, blah. So they really, even if OCTC thinks at the end of the day, this particular conviction will not involve moral turpitude once they do the investigation necessary, they still have to transmit it if there's any possibility, as I read that statute. The other thing, and so Ellen's idea of having a confidential transmission that at least allows an ENAC or allows the review department or whoever, I forget, these things bounce back and forth, but whoever the decision maker is, to make an initial determination that the conviction either represents moral turpitude per se or is likely to be moral turpitude after evidence is taken, that would have to be presented to the legislature. And this is the issue of lawyers with criminal convictions is kind of a hot button issue at the legislature. And as we've already been reminded, we recently did propose an amendment to the time period. It used to be 5 days, I think. The transmission period was 5 days, which was just not realistic. And it's now 30 days, but we asked for more time. And so the fact that the legislature reduced our request to 30 days is a confirmation of how strongly they feel about dealing with attorneys with criminal convictions. So my view is, and I think the board's view is likely to be, that trying to amend this particular statute to incorporate an ENEC process or some confidential process is not going to be well received by the legislature, and probably should not be something that we use our political capital, so to speak, because we can only ask for changes in so many statutes per year. And so I just want to throw that out there, that this just may be a very tough nut to crack, even if you agree with the policy. And I'm not 100% convinced that a ENEC is even needed for these cases myself, but I think the political ramifications of this may end up being predominating.
Thank you, Sean. Judge Wang.
I hear you, Sean. This is what I was struggling with when I was looking at 6086.1 versus the 6101. Under 6086.1 defines what public proceedings are. In terms of the way original jurisdiction matters reads, it's following a notice to show cause. A transmittal is a transmittal to the review. The review department initiates the notice of hearing. The hearing department issues the notice of hearing. So essentially the state bar court is noticing the respondents of the filing of charges. The transmittal goes to the review department as a transmittal. Then the review department sends it to the hearing department to hold a hearing. Then on the hearing department's receipt from the review department, we generate the notice of hearing. So I'm not sure where it's become the practice. I've only been on the court since 2019. I don't know when the practice has become in interpreting the statute to make the transmittal the document that triggers it to be public. So I hear you, Sean. I'm just not sure where the genesis is of the interpretation of the statute, and maybe George knows, because the 6101 just has that shall language that Ellen reads in a different way that OCTC does in terms of the transmittal itself. But that's why I was wondering if the recommendation, we're not changing the time frame at all. OCTC still does what it does, and it would be a rule change in the state bar court to say on the review department's review, they can refer it, instead of referring to the hearing department to hold a hearing, but refer it to the hearing department for an early neutral evaluation. Again, I don't know if that satisfies everyone, but in terms of the challenges in going to the legislature for a big ask, I'm wondering if that would ameliorate some of those concerns. And I think, Sean, you kind of touched on this as well. Yes, we do want to treat criminal convictions seriously. Moral turpitude and moral character, those things are tied to many of the cases that I see. But I also want to emphasize there is summary disbarment, there is interim suspension. So the review department still places people on interim suspension when there's a moral turpitude issue. The cases that are coming to me, the ones that are settling early for a private or private to the extent that we can do it, are usually the misdemeanor offenses that are not in the practice of law, where we don't have this, a huge issue in terms of noticing the consumer, because the review department is going to take care of the cases where they naturally involve moral turpitude. A petty theft, they'll be put on interim suspension. Grand theft, they'll be put on interim suspension. Again, summary disbarment, we don't see those cases. So those are some of my points in response to some of the thoughts I've heard.
Thank you, Judge Wang. George.
Sorry, forgot I was muted. I just wanted to go back to a few things, and one, just emphasize that one, we're talking about a limited set of criminal convictions, and I think Ellen said this, but this is really just for misdemeanors that we're talking about, not felonies. The second thing I wanted to emphasize was I believe I read the statute as Sean does, which is we are required to make the referral within 30 days if it either involves moral turpitude or may involve moral turpitude. And once we make that determination that it may, we then have that statutory obligation to make that referral within 30 days. So I do think that there would need to be some change there. The other thing I wanted to point out is that the review department to whom we refer is basically exercising a power that is delegated from the Supreme Court, because the statutes actually direct us to refer to the Supreme Court. And so not sure how that would weigh in with respect to rule changes, since in essence, it would be changing procedures that potentially would affect the Supreme Court's decision as to delegation. So I just wanted to raise those three things.
Thank you, George. Sean. You're on mute, Sean.
George, thank you. I have to say criminal conviction matters have been among the most difficult for me to get my hands around as a board member. They're just really complicated and arcane, really. So the fact that if the cases we're talking about here are all arising from misdemeanor convictions, that catches my attention. It may be possible to make a reasonable legislative proposal to have a different procedure for misdemeanor convictions as opposed to felonies. Because that's an easy distinction to understand. All the other stuff about criminal convictions, that the defense bar and OCTC, you do this on a daily basis. As many times as I've heard about this procedure, I still struggle to fully understand how it actually works in practice. But I just toss that out as an idea. If there is interest in reform in this area, that might be a sellable proposition.
Okay. Thank you, Sean. Ellen.
Just very quickly, I just want to point out that unfortunately, substance abuse is a big problem in the legal profession. So we're not talking just about the old cases that came to light after the fingerprinting. You know, it's still a fairly common type of misdemeanor that makes its way to the state bar. So I do think there's a continuing issue here. I also just want to say, and again, I don't mean to be unduly critical, but the review department, as did the Supreme Court in the Kelly case, has regularly and often concluded that a state bar disciplinary case based on 2 drunk driving cases, unless there's some additional aggravating circumstance, are not crimes involving moral turpitude. So we have a body of case law where the courts have found, including the California Supreme Court and repeatedly the review department of the state bar court, that these what you might call, you know, run-of-the-mill DUI cases do not involve moral turpitude. And yet we still see them being referred frequently. And, you know, I just want to say one last time, OCTC does have the discretion and has exercised it for time immemorial to look at a conviction and conclude that it is not a crime involving moral turpitude, not likely to involve moral turpitude, and that does not get transmitted. There's no statutory requirement that it be transmitted. So we're talking about OCTC utilizing the same discretion that it's always had, but building in a piece that at least gives the respondent an opportunity to present their case before the matter gets converted into a public disciplinary proceeding, which can never be expunged. That's all that we're seeking a solution to do. Thank you.
Thank you, Ellen. We will talk about expungement, hopefully shortly. Jerry.
Justin, I've been fascinated by this discussion. I agree with Sean. There's something arcane here. So, but I want to just build on what Ellen just said. And we just had we thrashed this out in Illinois. What do we do with the second misdemeanor DUI? It becomes a felony after that. And we believe we're in sync with a lot of states surrounding Illinois that those don't see the light of day if the lawyer is in treatment. And we have a different process to authorize charges. It's informal, but it has a board membership, kind of like a grand jury. So it's an old school system. But if we had to bring cases or decide to bring cases or not under a tight time frame, we might make some judgments we don't think in retrospect were right. And you get back to resources too, right? So if you're bringing 3 cases or 10 more cases than you should, it's not just, it is the critical is you're creating a public record in a regulatory environment of something that maybe didn't need it, but also you're creating resource responsibilities and drag on the system. But I've been quiet most of the time. I'm trying to understand what's going on here, and it is arcane. Thank you.
Thank you, Jerry. Melanie.
Yeah, just building a little bit actually on what Jerry just said is, you know, I also just want to highlight, without going too far down a rabbit hole, that, you know, part of the reason why it takes time for us is that we're trying to get information to determine whether or not cases involve moral turpitude or not. So, you know, it's especially difficult in these older cases. The transmittal has to be when we get the certified record of conviction, but that is only a little piece of the puzzle. And the rest of it, for example, might be in a DA's file, it might be a police report. And those are the things that we are working on during the time that we're, transmitting and trying to decide if we are in a position to settle a case or not. So we're not really living in a perfect world where we have everything and we know the universe of everything at the time that we're required to make the transmittal. And frankly, that would even be true if we were having to go to ENECs before we have the universe of information, which is exactly one of the reasons why we sought the rule change to get a deposition from the respondent, because oftentimes the respondent is the one who's in the best position to provide information and is not always terribly forthcoming in doing so. So there's a lot of challenges to this. I also just want to highlight, Judge Wang, I heard you say that our transmittals include copies of police reports, and I'm sure that there's a reason why you believe that. So maybe you've got some experience with that, but I will say that my understanding is that our transmittals, generally speaking, do not include police reports. And frankly, oftentimes we're struggling to get police reports to begin with. So thank you.
Right, sometimes that's why I stated it as sometimes it's a statement of probable cause. Each county does it differently, but it's not information that would normally be in the criminal docket.
Thank you, Judge Wang. Sean. You're on mute again, Sean.
Oh my goodness, how sad. Thank you, Justin. I think we're kind of at the end of the useful life of this discussion for today. And I also think, and we're running late, I also think we need more specificity to make the next discussion of this useful. So we should have a list of whatever the specific proposals are. So Ellen, for example, whatever proposals you think we should do, like write them out very specifically so we can go through them. I mean, is the effort to try to have an ENEC before the 30-day transmittal? I mean, that doesn't seem realistic to me. Is there a desire to look at whether the transmittal could be confidential in certain cases until a state bar court judge has made some kind of determination and or had an ENEC? But let's make it a little more specific, because we also need to sort out what is within the purview of the board to make a change to and what requires a statutory change. And in either event, I think we need specificity, because this is just so arcane, so complicated, that there's the high level discussion, I think, we're not really making progress with it.
Thank you, Sean. I think I have a couple more granular recommendations in terms of like extending the time could be one for the misdemeanor convictions to 60 days, and then working with Judge Wang on whether or not it becomes public, if there's an opportunity, if they're, fleshing that out more. And then if Ellen has something more, then I can get another proposal. But I think I have what I need to bring back, specific proposals on that piece. Mr. Farwell, you have your hand raised.
Yes, thank you. I know I missed part of the discussion, but I did want to say that I think the state bar should not consider DUI arrests or convictions, in particular misdemeanors, in any way, form, or manner. I'm not sure how to change that policy, but it should be eliminated. And my reasoning is that, number one, it has nothing to do with protecting clients at all, that I see. So the state bar doesn't need to get involved in that with the DUI. And secondly, I think it's become clear in the last 5 years in the United States that police departments are inherently racist in how they handle Black people, in particular Black men, and stop them and arrest them for things they should not be stopped or arrested for. And if the state bar is using that as a reason to further harass and intimidate, and a reason to cause problems for the arrestees, that is the definition of systemic racism. So I think if the state bar is serious about trying to resolve the problem with how they focus on Black male sole practitioners, that this is probably one of the primary areas in which the unfairness is shown. So again, my recommendation, I would hope that we can try to eliminate the reporting of DUIs to the state bar. That's my statement. Thank you.
Okay. Thank you, Mr. Harwell. So I think I have enough for the first part of the discussion. We are running behind, and I was hoping to get to at least expungement on the website. The second piece of the NECs was about timelines for the NEC process and subsequent, and it didn't come up with specific timelines. It's more about a policy, whether or not they think they should or shouldn't. Is that fleshed out enough where we can write that up and do an up and down vote, and the commission can, decide whether or not they think they should be timelines or shouldn't be timelines for subsequent ENECs? In the interest of, I don't want to cut off conversation, but in the interest of time, I'm looking for some confirmation. Sean.
Well, my thought on this has always been that it would be helpful to clarify that a second or subsequent ENEC should be had only if the judge believes there's a reasonable chance of a non-public resolution, because otherwise there's no reason to delay the filing of the public charges. So that's the one change I would make. And I'd be perfectly in favor of having some other time guidelines about the ENECs, particularly for those matters where the filing of the charging document is being delayed.
Okay, Ellen.
Well, Sean, that's only correct if we take Leah's suggestion about eliminating cost increase upon the filing of the notice of disciplinary charges, because the main negative impact on the respondent is financial. Once the notice of disciplinary charges gets filed, then a status conference occurs and dates get set and the costs start jumping up. So those two things would have to be done in tandem.
Steve.
Thanks. I don't disagree with Ellen. I think there is a difference in the schedule for, the ENEC. Although I think that the schedule, and Justin, you could put it back up if you want, that there's a relatively minor increase between the pre-filing of the NDC and the first 120 days. If I remember correctly. That's not to say that we couldn't rectify that, right? We could level that out so there is no difference there, which I think is the point that Ellen is making. But I think if you're looking at the difference between 3,693 and 4,317, at least compared to the 8,900 when you start talking about trial and whatnot, or even just before trial. The delta there is not huge. We could reduce it further or eliminate it, and that would hopefully solve some of that problem.
Okay, I think I have direction on this. And without any objection, I'm going to move forward with expungement on the website. Stuff we have discussed before, but want to bring back. We probably only get through part of this, but I am going to share my screen. So the two goals for the expungement are determine if the commission supports a reduction in the length of time discipline is available on the attorney's profile page on the State Bar website. And then the secondary thing to look at is determine if the commission supports the expungement of the discipline record and under what circumstances. And so the first part of this is expungement from the website. And we have talked about this before, but this is talking about what makes something public. There are statutes that make certain things public, and that we had Office of General Counsel opine that the state bar is not specifically required by statute to post its discipline online. It does promote transparency and facilitates the public's right of access. So the expungement working group started by looking at other states. We had a report from a couple of years ago, and we did some follow-up. The expungement on the review of the other states, most other states have discipline records online. 2 of the larger states, Florida and Texas, only have 10 years of access online. And so this will start to become a theme at other jurisdictions and other DCA entities that we looked at. 10 years was kind of a cutoff point for certain things. We also looked at nurses and doctors and did a comparison of those and the different levels of approval, private approval, public approval, basically ADP or diversion programs, probation, suspension, and then disbarment and revocation. And this is just what's on the website. And so you can see that public approvals for doctors are removed after 10 years on the website, and for nurses after 3 years on the website, and for attorneys, they're there indefinitely. And we had a public member submit in writing, and he also appeared at one of our meetings talking about how his public approval he got very early on in his career, 16 years later, was still there when he was trying to find another job, and the impact that had. So looking at comparable agencies, we really kind of focused on the nurses. And this is a snapshot of the nurses website, and it clearly states what is on and what isn't on the public website. And it talks about the balance of the public's right to be informed, and also the health care practitioner privacy concerns for those who have fulfilled their disciplinary requirements. And so it clearly shows what's on there and what's not. It doesn't mean that the information isn't still available. It's just what they put on the website. And so taking all of these things into consideration, and this is very high level, and we talked about this at our last full ad hoc commission meeting, the working group came up with recommendations for the length of time that things would remain on the website. And private approval, they determined that when the conditions were fully met or 1 year, and you might say, well, private approval, how is that on the website? And to refresh everyone's memory, when the notice of disciplinary charges is filed, that is public. And so if the ultimate outcome of that notice of disciplinary charges is a private approval, that's the level of discipline, it is on the website and remains on the website in perpetuity. Then public approval, the decision was 3 years. Probation with stayed suspension was 3 years or the conclusion of probation. Probation with actual suspension was 5 years from reinstatement. Disbarment, the decision was to have that permanently on the website, and that was to combat the unlicensed practice of law. So if someone was representing themselves as an attorney and they were disbarred, we would like to notify the public in those instances. The discussion on whether the discipline was automatically removed if you met certain conditions, or if it was petition-based. The first 2 levels, the private approval and public approval, tended to be towards the automatic removal, and then anything with a suspension would be petition-based with that. And so having said those things and presented the high overview, that's what the working group recommended, and we discussed at the last ad hoc commission. There isn't uniformity in this. I know that the Office of Chief Trial Counsel and other members expressed some concern that those timelines are too short, and that they needed to be lengthened. And so I'm kind of opening up to try and see whether or not there's support for an alternative proposal in terms of length of time for the things to be on the website, or is this the proposal that we would like to vote up or down on, and just kind of have a discussion in the minutes we have remaining? And Eloise.
I have a lot of reservations about those timelines as a practitioner. I always look up the, in family law where I'm dealing with a surprising number of clients who have had previous attorneys who have been disciplined. These are for different things. But I think when there's, I would have been completely hamstrung in advising them if there was a 3-year limit on some of these records. They have to do with financial mismanagement of client funds. They have to do with suspension of, and put on probation at a certain period. These records account for difficulties that my clients have had in resolving their cases, or in statutes running when their attorney was unlicensed, was unable to practice law and they didn't know. So I have a great concern about that as a practitioner, because I can verify that the State Bar has been very active in tending to protect the public, but the public has included quite a, I would say in 6 cases in the last 3 years. I have been benefited from looking up the previous attorneys. And if I had not had that record, I could not have gained $50,000 from one of my clients in a post-marital judgment case, because she had, anyway, let me just say my concern. I would not have any problem dropping, just eliminating discipline for failure to pay bar dues or failure to turn in, eliminating these suspensions from the practice of law for these clerical delays of failing to turn in MCLE reports, that sort of thing. I have no problem with that. But it's the other matters where attorneys were disciplined, put on probation, either temporary or for 3 years. I think those records need to stay for a while because of the statute of limitations in family law cases where these times that they were disciplined affected, the history of the case that I'm trying to resolve.
Thank you, Eloise. Sean.
Yeah, so Justin, could you put that chart back up with the working group's recommendations? Sure, but I think the structure is right. In other words, this is a good structure to consider for adoption. I do tend to think the periods are a little too short. Private reproval is unique, and I could see increasing that to 2 years, but I could see sticking with 1 year. And I think it's something that the commission will want to discuss, because remember, everyone, when you have a private reproval that is publicly reported on the website or in our discipline records, that's a little bit of happenstance, really, because someone who resolves the case before the public charges are filed gets what's known as a truly private reproval, right? So that the judge, when you're instituting a private approval, it really is intended to be private. And it's just that we have this kind of anomaly in how our system works, that some private reprovals are actually publicly reported. So I think for private reproval, it's conceivable to me that a 1 year period is right, because someone who resolved the case before charges were filed would never have it reported on the website. For the other ones, I think I'd bump them up. I'd bump up public approval probably to 5 years. And then maybe the same for probation with state suspension, and actual suspension maybe a little bit longer. The other concept that I would add to the structure for consideration is that if the attorney has a subsequent incidence of discipline within a certain period, that reactivates it either restarts the clock, or it can even cause a prior incident of discipline to be restored. Because just as the auditor explained, and we've discussed at the board level repeatedly, pattern recognition is very important to evaluating the extent to which the respondent is a risk to the public. And I think the public is entitled to make that determination for itself as well in appropriate cases. So I would add that as a concept that should be considered and refined.
Yes, I failed to mention that. The working group did talk about restarting, you had to have no other discipline. We didn't talk about restoring previous things, and that's a good concept to add to that.
Okay.
Steve.
Thanks. First of all, I want to thank Sarah, who was on the working group with me and gave me permission to object to the to the working group's findings, because I agree. I think that these timeframes are way too short, and frankly, as I told the working group, that the consumer protection attorney in me really thinks that it is that the consumer would expect that they would have that information available. I mean, this is a minor point, but the studies are that nobody wants to pick up a phone. Nobody wants to call anybody anymore. They want to text, they want to go on the web, they want to do those things. And to have the information and, even with a disclaimer saying, well, there's more information, but you have to call us for it, just seems to me as odd. And I agree that the statute doesn't say we have to post the information on the internet. But at the same time, the statute was passed before the interwebs were available, right? And it's been in existence since before the internet, certainly before the internet was a big thing or a well-known thing. And so I think that's part of it. I think that these are too short. Generally, I understand the argument about public-private, et cetera, but I think the others are too short. And I also just want to highlight that my recollection, and Justin, correct me if I'm wrong, is that the working group made no distinction between publishing on the website and actually the expungement of it later, right? We talked about differentiating between them, but eventually the working group, I think, settled on the same timeframes for actual expungement versus removing it from the website. Is that right?
Yes, I wasn't going to try and kick off that discussion, but yes, the ultimate recommendations from the expungement working group were website and true discipline expungement were the same.
But I think it's important to bifurcate the conversations, personally.
My bad.
Sarah, or actually, I apologize, Sarah. Janet, you had your hand raised.
Thank you. I would recommend doubling the public approval, the probation with state suspension, probation with actual suspension. And I just think the consequences to hire the wrong individual is just too impactful for the clients. And the bottom line, it's just one word: transparency. Thank you.
Thank you, Janet. So in the interest of time, I think there are two competing groups. And I think, Sarah, you kind of represent the group that I presented and was with the working group and presented. And then Steve, you kind of have an alternative point of view. So I don't know if the commission would be willing to have me work with those that have obviously increasing these timelines and work with them to develop whatever those timelines are, so we don't have to do it right now and say, 4 years, 5 years, 6 years, what we would do if the commission would be okay delegating that authority to, one or two of the members that oppose, that I could work with to develop an alternative approach for these subjects. Is that seem okay with the commission?
I think that makes a lot of sense and would be efficient.
Okay. Thank you, Sarah. Now, Sarah, you had your hands raised.
Yeah, the only thing I was going to add, and so was to say something along the lines of what you just said, Justin, which is we should prepare two competing proposals. It sounds like there'll be a little bit of dissension among, how long is long enough for folks who don't buy into the proposal of the working group. But I leave that in your capable hands. The only thing I wanted to add was for those members of the working group who proposed this, a big consideration was, what do we do about the fact that we've had a very biased result of the disciplinary system that Farkas reported on? What do we do for all of the Black men who have been in front of the disciplinary system and whose lives and careers have been affected by it? And I think we were looking at some kind of remediation. and what might be appropriate vis-a-vis past things. And we hope going forward with all of these efforts that the disciplinary system will be de-biased to some extent, although any kind of bias is inherent in any system. And so it will also be available kind of in the future. So I just wanted to put that on the table. I know we're out of time. I have to get my car from the lot across the street at the State Bar. I'm sure Sean does too. So
yeah,
I think we defer that for another day, but just wanted to say that was a main consideration, was kind of remediation.
Thank you, Sarah. And I will, basically the progressive working group and the moral turpitude working group, I talked about it earlier, and progressive, we still need to meet. So those working groups still need to meet to flesh things out. And that's kind of the update on those. So I don't have anything further to discuss because I will work to bring back alternative proposals for the expungement working group to include in the report. That is all that I had to discuss today, Brandon.
All right. Thank you so much, Justin, and everyone for your time today. I think that we stand well positioned to wrap up the recommendations of this commission at our June meeting. So please do everything you can to make it to that meeting. I think it's going to be an important meeting, and really appreciate everybody who's working in the interim to complete all the work that we've discussed here today. So with that, unless there's any burning desire made evident by members of the commission, I would move to adjourn. And see nothing. Thank you all. Have a great rest of your Thursday.
Thank you, everyone.